for personal appearance of the police official to ascertain the stage of the FIR, my lords.
Not should we recollect, this is the sale deed registration matter.
Yes, my lords. The charge sheet has already been
When it was filed?
filed on October 2025.
Within what period charge sheet needs to be filed under CRPC as it then was?
It is if
90 days.
arrested 90 or 60, it is
60, maximum 90.
90.
What is the explanation for the delay?
My lords,
We will direct disciplinary action against your inspector.
my lords, he was not the
I
IO.
don't know who was there when he came to the station.
He came to February 2025.
February, and he took November, up to November he took time.
My lords, he is the supervising authority, he is not the IO.
So we take
was-
action against the supervising authority, not IO, because he did not supervise.
My lords, I was also telling them why you have.
Ask what is the explanation? Why for the previous period, who were the police? All corrupt in the third rate. Third rate. How many years, how many sales have, fraudulent sales have taken place? What should the citizens do?
My lords, it is rampant in Bhubaneswar and Jatni.
Why they have not filed the charge sheet in time? They are one with the buyers.
In fact, the accused was, by order of this honorable court, was released on bail.
Therefore, it was easy for the investigation.
No, my lord. That is not the. They released in last 24, and the IO was chased.
When he was arrested, give a full detail. No, we will not like all this. We will take stringent. We don't care our government because government is not caring the citizens.
My lord. My lord, I questioned him.
Ask him to, not questioning, ask him to file the affidavit. I will not leave it that way. Such things, how citizen will be safe at the hands of such police? Huh? How? Tomorrow you just go and check your property records.
My lord.
Your house may not be in your name now.
And particularly that area, it is rampant.
Everywhere it has become a menace. That is how we are taking it.
We have to stop it, other people will not believe judiciary.
My lord.
No, we need a complete detail as to when things happened, who started investigation, nature of investigation, when the investigation was completed, how many police officers came and gone. Everything we need, we will not live that way. We are not here to make tamasha. We are very curt. We are very curt. Ask him to file. Ask him when he will be filing entire, when the FIR was lost, when the investigation began,
My lords.
when he was
Details.
arrested,
Yes.
then what happened? The entire,
My lord.
by our order dated 28/1/2026, we had said as that first time, pursuant to said order, SP.
The IIC Jatni police.
IIC,
Huh.
IIC, Inspector in charge.
Inspector in charge.
Jatni police station.
My lord.
Inspector in charge, Mr. So and so, has appeared before the court with no preparation whatsoever required for the assistance in the proceedings. First time, he has come as a mute spectator. So on the last time, the government advocate was told that the entire report would be necessary as to the criminal delay proved in filing the charge sheet. Charge sheet. First time. Anyway, next one. Anyway, a short period of 2 weeks is granted to come up with a comprehensive report as to the investigation and the delay in filing the charge sheet. Charge sheet. First up, if the officer is warned that in the event the explanation offered is not plausible, comma, he runs a tremendous risk in terms of career and job. Yes. Call this matter on. Which date? Give him date. Tell him, ask him which date he wants. Next date, the entire report should be here. We will not leave you. You are playing with the lives of the people. Just choose a date. Which date? On 25th, gone on 25. 25, 3. 24, 3. Huh?
25, yes.
25, 2. So, on the said day, the officer shall be personally present before the court. Send a copy of this order to the commissioner or superintendent of police. Who?
SP.
Send a copy of this order
DCP.
to the
DCP Bhubaneswar.
SP Bhubaneswar.
DCP
Bhubaneswar, who should vet the report to be filed with all responsibility, failing which action may follow against him also. Yes, on the second-rate departments. Yes.
Item 1.
Yes.
4 writ applications, my lord. Union of India has filed 4 writ application. In first item, I am appearing for the Union of India, and so far the 4 before my learned friends are appearing. Here, there are 4 writ applications. Same state of facts, my lord. Here the round of challenge, my lord. Here the opposite party was appointed in the year of 1980 as lower division.
Make use of your mic.
The opposite party appointed in the year 1980 as lower division clerk, my lord.
LDC.
LDC
1980.
on ad hoc basis, and there is a condition that he has to pass the relevant examination for regulation of his services, and accordingly he has passed the examination in the year 1986, and he has succeeded and he has regular.
One sentence, full stop. We have process na. 1980 amendment, appointment,
1980 is the ad hoc appointment.
ad hoc appointment. And within what period he was supposed to pass the examination?
No, he has after the relevant rules came into force in the year 1985, there is a recruitment process, and in the year 1985 the applicant faced the qualifying examination, and his post has been regularized on 13 to 1986.
All 4.
Well,
13
to 1986.
regularized as
LDC man, that lower division in the same post man.
okay. And then
Then
what happened?
after my lord, few years in the year 2015, he has filed a representation to count those period from 1980 to 86.
In regularization.
And his representation has not been considered. He approached the tribunal, and the tribunal directed to consider his representation. We have rejected his representation, and thereafter he filed another original application, and the learned tribunal directed to regularize these posts, relying on 2 decisions of Guwahati High Court and Bombay High Court, where my lord, a compiler, there is no provision for recruitment process. Only that is the point. There is no recruitment process, but the compiler post was directed to be regularized from the initial date of appointment.
Yeah.
So considering this Guwahati High Court judgment and Bombay High Court judgment, learned tribunal has directed to regularize from 1980 to 86 for the post, regularize the service of the applicant. That is under challenge in the seat application on the ground that
Or CGSC.
Central Government Council.
On what ground you are challenging?
Ground, my lord, since the appointment order clearly says that he has to go through your lordship page 149, that is the order of the appointment. That is also annexure 8. I have annexed 172. Here, my lord, a condition is that the appointment is purely temporary and ad hoc basis, and he will have no claim for indefinite continuance. In the unlikely event of his continuing beyond 1980 to 83, he will have to pass the relevant examination conducted by the Staff Selection Commission for his regular appointment in the post. The ad hoc appointment will not bestow on him any claim for regular appointment, and the ad hoc service rendered by him will not count toward the seniority and promotion. So only on that ground we have challenged, my lord.
Which
Because
examination he was supposed to
the
pass?
staff selection examination.
Show that. When examination was held?
This examination was held, my lord, on July 1985. He has qualified on 13 to 19. Thereafter he qualified and his post was regular 13 to 1986.
Yes, he has
That
qualified also. Examination was held and he passed.
He passed.
Correct.
He passed.
But
But
then-
for the past services, which ad hoc basis, he claimed for regulation, that has been rejected.
For the purpose of terminal benefits, how?
Yes,
For the other things we can understand.
That is
that is
the
the direction of the tribunal, Your Lordship. Your Lordship, page 90.
Only for terminal benefits,
Yes, SCP and MSc benefit.
then that has to be done.
And in view of the Honorable Apex Court judgment in Guwahati, confirm that order. These are not good.
Then what remains here?
But
These
they
are-
are the post of compiler. There is no examination process.
It still makes your case still worse. Here is an examination which has passed.
Passed.
Then it makes your case worse.
Yes, correct.
Take note. Who are you?
And there also
I
the
am in the third
Employees.
third
Employees.
item quite different.
You are also in other matters.
I am in the third matter, my lord.
Anything you want to add to what he has argued? No repetition.
My lord, two things are to be considered. Every appointment should happen accordance with the rules. There are principles, my lord. Employment exchange has to be involved. SSC has to be involved, and
Who makes the appointment?
appointment, it is Union of India made appointment for candidates. Those are regularly appointed. My lord, in this case, this person is not a regular employee. He was appointed under 1991 census. In my matter, he was appointed on ad hoc basis, my lord.
All are appointed
All
on a
are
ad hoc
appointed.
basis only.
My lord, Lordship may kindly come to Annexure 4, my lord. My matter,
In item 3,
my lord.
8934.
My matter.
No, sorry.
Eight-
Item 1,
8934 of 25.
893. Sub-
My matter, Annexure 4, my lord. This is the order, my lord. Annexure 4. Order of regularization, my lord. The order says that in pursuance of the approval of the competent authority communicated in the letter number 31016/2000 dated 29/6/2004 of the Office of the Registrar General India, New Delhi, the following ad hoc employees of this office in respect of whom there is no case pending in any court are hereby regularized in service in their respective post with effect. The date of issue of this order, Lordship may kindly see, the date of issue of this order, next line, my lord. The ad hoc service rendered by them prior to their regularization will not count for the purpose of promotion. Lordship may kindly see, for the
Correct.
purpose of promotion,
Correct.
seniority,
There is no
promotion.
that they are demanding.
Right?
They want it to be retrospective, which is not coming under.
You are asking for
They want it
promotion?
retrospective.
No, he is saying no now. We'll record his application.
Yes, Your
Lordship may
Lordship.
kindly record.
SCP and
It will not
MSc.
be.
Other service progression, etc., we will not consider.
My lord,
For terminal benefits, yes.
regularization has already taken place, my
Your
lord.
Lordship,
Therefore, they are
But
saying,
antedating it to the date of initial appointment shall disturb the status of other regular employees.
no, they are giving up everything.
Your
That may
Lordship,
kindly be recorded, man.
Yes.
Your Lordship,
Yes.
So far,
I-
other rate applications concerned, dates are quite different.
Yeah?
Dates are different.
Ah,
it
yes,
is, it is, it is, Your Lordship. Take-
Check down. Kindly be seated. No, his apprehension is, suppose if we treat it with retrospective effect, if others already in the seniority list may be affected.
What happened?
Disturb the entire.
In this case, what happened, Your Lordship?
No, anyway, you have said,
Yes, Your Lordship.
it is, where is the order?
It is the operative part,
Read the operative portion of the order.
page 19, Lordship.
Page 9.
Read it.
First rate application, page 9.
19, Lordship. In view of the
Annexure
discussion
1.
above, the order dated April 5 is quashed since it is illegal and arbitrary. Consequently, the respondent directed to extend similar benefits as they granted
to other similar situated employees and regularize the service of the applicant from his initial date of joining and grant him all constitutional benefit for the purpose of SCP and MSCP pension.
Only terminal benefits we can
Yes.
grant. Rest of the things we cannot.
SCP, MSCP and pension benefits. That is the financial benefits.
ACP,
MSCP and
MSCP and pension
ACP
benefit.
means
The assured career progression, that is financial benefit after 12 years.
Huh?
Assured career progression benefits, that is financial
career
benefit.
progression benefit.
After 12 years completion, they have get the financial benefit.
SCP, second SCP.
Second.
So this will be counted for the purpose of
Purpose
SCP you want to say.
SCP,
So the
that-
service rendered during the period of ad hoc will be
Yes,
counted for.
Yes, Lord.
ACP.
SCP, MSCP and pension benefit.
Yes, they already done that way, na?
Once,
In view of this honorable court's order,
Yes.
and department is tagged,
That order.
Your Lordship, I will draw on that, Your Lordship.
Annexed.
In view of the honorable appeals court judgment, Your Lordship, page,
the ad hoc period will not be counted in SCP, and it is clearly stated the benefits which they
You have to
then
kindly-
get, that will not go. The ad hoc period will not be counted.
It will not be terminal benefit.
No.
page
Terminal
60.
benefits we can allow.
That is the rule, my lord.
Then I will come to page 61, Your Lordship.
61.
Page 61. Page 61, Your Lordship. This honorable court's order, 22/4/2014, Your Lordship.
101. 101.
It's 101. 101. Lordship, paragraph 5. Lord and Additional Solicitor General submits that challenge in the present petition is to the order of regulation passed by the Central Administrative Tribunal, Cuttack Bench, Cuttack. Similar challenge has also been made by some similar circumstance employees from all over the country pertaining to the census operation, Your Lordship. It is also reiterated that against the judgment passed in dated 5/6/2009, passed by the Honorable Guwahati High Court in WBC such and such, the Union of India moved the Honorable Supreme Court, which endorsed in the view of Guwahati Honorable High Court by the order dated 16/4/2012 in special leave application dated 19/8/2010. It is submitted that the Ministry of Home Affairs and the Department of Personal Training, after obtaining opinion of the legal affairs from the Ministry of Law and Justice.
Yeah.
Affairs from the Ministry of Law and Justice has directed implementation of the order dated order of the Honorable Guwahati High Court, which was confirmed by the Honorable Supreme Court. The Ministry of Home Affairs in the Office of the Registrar General by its letter dated 4/7/2013. That is all of DCO that has been given. I will show that document. Requested to the controlling authority, all DCOs, to inform the cases of direct recruitees appointed on an ad hoc basis in all cadres who have not been regularized in the initial date of joining. It is fairly submitted by the Additional Solicitor General that in view of the efforts and direction of the Ministry of Home Affairs and order dated 5/6/2009 of the Guwahati High Court, as affirmed by the Honorable Supreme Court, the writ petition has become infructuous in the meantime and nothing remains for adjudication. In view of the above, since the writ petition has become infructuous, this court considers the appropriate to give direction to the concerned officers of the government, when in Department the census of complied with the request assured Ministry by 4/7/2013 by the Registrar General of India, Home Affairs, to provide necessary details of the employees who are yet to be regularized government in India in necessary action. It is further submitted such and such, and this is the concerned department of the government directed to take immediate steps.
We understood. I read that.
In view of the issue, Your Lordship, 4/7/2013, Your Lordship, page 95, Your Lordship. Government issued, that is that the Minister of Registrar General, Your Lordship, 4/7/2013, Your Lordship. The controlling officer all issues, including that the regulation of employees in all cadres appointed for 91 census. Guwahati Bench instructed accordingly. There's page 96. His name is there, Your Lordship.
96.
96, serial number 2, Your Lordship. First case, Your Lordship. These persons are on ad hoc basis. They have in core post. They have what means that the sanction post, Your Lordship. Your Lordship, another bit, that page 97 and 98, as per the Honorable Mumbai High Court, that has been LDC has been regularized in Maharashtra, LDC, Your Lordship. Kindly visualize Your Lordship, page 96 and 97 and 98.
With effect from which date?
My lord.
That is from the date of the appointment.
Come to page
Initially-
98
97 and 98.
in his petition.
Yes, Your Lordship.
Is it with effect from or with?
Yes, from the date of ad hoc service, Your Lordship.
Where is that?
That is the page 97, sir. In portion such and such, earlier direction by the Honorable Bombay High Court, Your Lordship. I also have the enclosed, Your Lordship. Training Minister of Law as a personal training has conveyed the approval of OSI such and such 28/3/2024 to implement this order.
Against each.
Yes, Lord.
When were they appointed?
They have appointed, here is the case, the period I have not known, ad hoc service that means when he has joined.
Your argument is not, it lacks clarity.
Your Lordship, what
We
happened?
are
Your Lordship?
asking.
Go slowly and ask.
There is 97, you asked us to look.
Yes, sir.
We are looking into.
Yes, sir.
In that, there is no indication that the regularization is with retrospective effect from the date of entry.
In view of the above, LDC ad hoc services of the following employees regularized with the consequential benefits in the lower division clerk with different dates mentioned against each.
Not dates of entry.
Yes, dates of regulation, you say 17/6/80, that is the date. Right, in
80.
Date of regulation.
When were they appointed? That they are not saying. Simple sentence is not there. Regularized with effect from the date of entry into service. That sentence is lacking. On the other hand, they have given the components of date marks.
Yes, Lordship. Mumbai,
In connection,
Mumbai High Court.
No, 17/6/1980
Yes, Lord.
is the date of entry as ad hoc.
Yes,
How do you say
How
that?
do you say that?
because Your Lordship, that order also, here also Bombay High Court, Your Lordship, page 63. 63, sir. Page 74, last operating party, Your Lordship.
63.
63, running page 74, paragraph 8. Accordingly, the read petition circumstances. Paragraph 8, sir.
Tell paragraph.
8, sir. Accordingly, read petition number such and such is allowed in terms of prayer clause, read petition number such and such, terms prayer clause be. Petitioners in both these petitions are entitled to regularize as LDCs from the date of their initial appointment. It is further directed that petitioners of both these petitions are entitled to the consumer benefit, including seniority and others. Here is a case, he is not claiming for seniority, only claiming
From
that
the date of their initial entry.
initially.
my lord, answering this one, union has relied upon the
Kindly come to page 74 or para 8 of Bombay judgment. Huh?
accordingly, the writ petition number 5
Correct.
for 3 of 2012.
Read now. Read slowly. It says from the date of initial entry. Therefore, he is saying that.
My lord, we have relied on the judgment of Uma Devi and
We don't know all that. This is when it was decided?
Decided in 2014, sir. 2012. 18/12/2012. Page
So
6.
Uma Devi was already there.
my lord says why we have relied on the judgment, my lord. One thing we want to bring to the notice of the honorable court that I am on Uma Devi judgment, man. Uma Devi says if regularization already made and not sub judice need not be reopened.
But
If
that is-
regularization already made,
Correct.
in
But these
2004,
are
my
the
lord,
cases.
in my case, apologize, my lord. In my case, the regularization has happened in July 2004, my lord. Uma Devi judgment came in 2006, my lord. So it cannot be reopened. Already regularization been made. Second thing, it says that, my lord, in ad hoc employment, when he has accepted the terms and conditions of ad hoc employment, now he cannot claim for the regularization, man.
No, that we don't agree. With it, he is after the bread to hold his body and soul together. Therefore, he is not in a bargaining position with the Union of India, which is a mighty entity. Bargaining power is not with him. He had no option than to accept it. That contention will not agree because that contention is rejected by the Apex Court in 1991. in Delhi Transport Corporation versus Workmen Delhi Transport Corporation. If they are having comparatively same bargaining power, then we can understand.
Lordship,
He is
may
a
kind-
daily wage.
Lordship, may kindly hear me. Paragraph
We are hearing
30,
you.
paragraph 38 of Uma Devi judgment. madam.
Let us see 1 second. We answer your question. We'll come to that also. Come to your paragraph 8 you have read, na?
Yes, sir.
This is post Uma Devi judgment.
My lord.
Do you agree?
This is post Uma Devi.
Uma Devi judgment. Then this was it challenged before the apex court?
No.
No.
They implemented that report.
You have implemented that judgment.
97 and 98. Yes.
Now, how can you say for these people we will implement, for others we will not? And Uma Devi was almost 4 years old by that time. 5 years old. 2006 it was.
Lordship, may kindly give a short adjournment.
No, Judge.
We will take instruction on
No,
this.
we don't know all that. We will take instruction for SLP. We don't do that now. We never do jobs on an installment basis. This is number one. And that 97, 98 are implementation orders. 97, 98. This number
Yes, Lordship. 97, 98.
97, 96.
are implementation. Implemented when?
2014 में.
2014. So after 2 years. What happened to the review petitions? No, they have said the subject outcome of the review petition.
That is, till today they have not answered. And thereafter, Honorable High Court order, they have to be implemented. And department take a decision, conscious decision, that we will give all the persons to give the benefit.
Mr. Padi, do you want to add anything in their favor? You have taken a policy decision. These employees are spread all over the country. Some of them went to Bombay CAT, secured order. You challenged it before the High Court. You failed it. Then you said we'll implement this order, subject to review petition. There is nothing to show that you have filed any review petition or review petition is allowed, rejected, etc. It is not your case that you have taken the matter to the Supreme Court. It cannot be because you have implemented the orders. How can you deny similar benefit to all these people?
Process of selection and evaluation. It is a question.
No, that has been already considered. That contention is stated by Bombay High Court.
Only this issue, because
Yes, sir.
if a person is not coming in proper selection process,
That is rejected. That contention is rejected by Bombay High Court. In 2012, post Uma Devi, you did not cite Uma Devi there.
that was not taken into consideration.
No, where have you cited? In Bombay, you were not there, na? In Bombay, whether Uma Devi figures.
Yes, 72.
Till the page number, the paragraph number. Pages differ from case to case, na? Whether Uma Devi was pressed into service in Bombay. Or you want to press Uma Devi only in these matters? You cannot do that. We will not permit that to do.
It's true.
You have to be uniform.
But the points of law cannot be ignored by them.
That's what.
Points of
As against you.
maybe, but
No. They're all poor people. Regulation has been granted. In rest of the country, you have implemented. In rest of the country, you have implemented. Cuttack is part of this country only.
may I pray one thing? It is not advisable.
No, will not.
Because you will take only instruction of
No,
the reviews,
nothing like that.
otherwise
No, it is your petition.
our petition.
If it be their petition, we would have understood. It is your petition. No time will be granted that way. People will laugh at us. Yesterday we took more than 2 hours for reserving a matter.
But here what happened, order has been passed by the land secretary, against which you will pass the restriction. So we don't have any scope to go for a review or anything because as regards the Bombay High Court, Bombay order is concerned. So any order passed by any court is not confirmed with the Supreme Court. Then this court is not binding on this.
No. That's wrong. to say the least. After Kusum Ingot, we were taught in the law school that judgments of one high court are persuasive for other high court. That was the law. But after Kusum Ingot, there is a big shift in that approach, where the employees or any law relating to central government, which is applicable to rest of the country, if one high court interprets that law, the other high courts have to follow the same. Not just persuasive, it is more than that. Though it may not be very, very binding in the sense of Rupert Cross's precedent in English law. It may not be. But that is what that says Kusum Ingot versus so and so. That has been interpreted by various high courts. One such judgment is of Karnataka High Court, 2012 Karnataka. If union law or law relating to employees of the union government are concerned, there has to be uniformity. Otherwise, the same employees will get that benefit in Assam, not in Manipur.
It is a discrimination.
That cannot be. On that ground. Take note.
And once an order has been passed by the Honorable Supreme Court way back in 2006, man. Now Bombay High Court has come up with a decision in 2013, man. It's a decision saying once order is passed by the Honorable Supreme Court, it is a precedent which is binding upon all the constitutional courts of the country.
Correct.
They have not relied upon that, or they have not.
Where have you to show that that judgment was pressed into service? You can't say, I did not argue the matter. That is no answer to us. Your counterpart argued the matter. 2012, Umadevi was very much there.
Only one point is here, another point in our and a delay of 20 years. They are scheduled since court.
Where is the 20 years?
Just because this regularized service in 1985.
Correct.
And they are come to the court in 2050.
Are they in service as it?
No, just retired, Your Lordship.
They are retired.
Yes, Lordship.
You let them take terminal benefits.
Yes, Lordship. The only benefits of that is the recipient benefits. You
Not ACP, etc. You have said no, that all that you will not get. You will get terminal benefit.
Your Lordship, what?
Is a consider.
Your Lordship,
They are coming to this.
Your Lordship, kindly page 95. Page 95, Your Lordship.
No, but you agreed when you opened your mouth and the argument when you
Yes,
said,
ACP
said that we will be happy with the if the service is counted for determining the terminal benefit.
Yes, there is ACP, Your Lordship. In counting the service benefit, ACP will count.
That also will count.
Yes.
Well, but only salary you will not get.
No, not
But
so.
only thing is that will be taken into account
yes.
for terminal benefits.
Your Lordship, page 95. But my Lord Senior, that department himself, Registrar General of India, consciously decide to all the employees. Page 95, sir. 95. Ask the controlling officer all DCOs.
No, this is only format.
Such format that said that they have took a decision. All the persons regular, those who are not regularized that out of period, that should be regularized. Accordingly, my name has been given to the
We will say, as Mr. Patil,
Supreme Court.
we will say that for determining the terminal benefit,
Yes, sir.
you count the previous service. Are you agreeable with that? Otherwise, you will admit it and keep it for 5 years. Which you want.
SCP, that is the comment to picture, that is the SCP. SCP.
Then you give a memo to us. But tomorrow, if you take up a contention before the apex court, we will not be there to defend.
But my sole contention is because the court has not directed regularized service for the purpose of seniority and that is what the
That you write and give it.
that is the recipient court has directed the recipient promotes that is the benefits from retired benefits.
You whatever you are saying orally,
Yes, sir.
you give a memo to that effect. Saying, we have read that order. We have read it.
It has been already been passed by the Honorable Tribunal Lordship. That is the only regularized service applicant from his initial date of appointment granting all consequential benefit for the purpose of only SCP, MSCP, that is the retired benefit.
That itself includes terminal benefit, not other service.
Once it has been regularized that period, then SCP, the financial benefit would have been regularized.
So you will get a little more pension.
Little more pension.
All these petitions by the Union government and its officials kindly be seated. Seek to lay a challenge to the orders of the tribunal, Central Administrative Tribunal, Cuttack.
Cuttack means good.
Kindly sit and answer. Whereby the subject OA numbers so and so, so and so, so and so, so and so, having been favored, comma, an order of the following kind has been passed. One order you reproduce. First one. Next one. Learned DSG, assisted by CGCs,
Senior Penal Counsel.
Senior Penal Counsel, so and so, so and so. Submit that.
And also
submit
TGCs.
that. Right?
And also-
I am senior panel counsel
Some
member.
are senior counsel, some are six.
CGCs, Senior Penal Counsel. Yeah. Submits that. The regularization having been done in the year 1985, subject to certain terms and conditions. Come on. The employees years thereafter could not have complained against, could not have canvassed their grievance in the OAS. When Section 21 of the Administrative Tribunals Act 1985 prescribes a period of limitation of 1 year, little relaxable as well. Semicolon. Always, the regularization of irregular service does not to the benefit of the employee except for certain limited purpose, such as determining the terminal benefits. Even the ratio in the state of Karnataka versus Uma Devi comes to the aid of petition. First, so arguing, he seeks following of the writ petitions by setting aside impugned orders of the tribunals. First one. Next point. Learned advocate appearing for the OPs, private OPs, with equal vehemence, resist the petitions, making submission in justification of the impugned orders and the regions on which they have been constructed by the government. First of all, he contends that in Maharashtra, the services of similar employees have been regularized with the retrospective effect pursuant to the Central Administrative Tribunal's orders, Hon'Ble Central Administrative Tribunals, pursuant to orders of Central Administrative Tribunal, Hon'Ble. Therefore, the union government being an entity under Article 12 cannot practice discrimination. So it is expected to conduct itself as a model employer. First. He also draws our attention to the very same Bombay High Court judgment, to the Bombay High Court judgment in
I read WPC 543 of 2002 at page 63.
in WPC number
5-4.
543 of 2002.
543 it
It is
is,
63, sir.
of 2002. Dispute of White Order dated 18/12/2012, wherein a direction has been issued for regularizing the services with the retrospective effect from the date of entry, and for granting regularization to the service benefits.
And also, declaration by this Honorable Court, by the Additional Solicitor General, page 99, before this Honorable Court, Your Lordship.
Similar matter.
Yes, Your Lordship, that is the regulation for the compiler, Your Lordship.
Huh?
For the compiler, Your Lordship, in that census
The
operation.
compiler.
Yes, census operation, Your Lordship. That ad hoc period.
In the same department.
Yes, Your Lordship. Page, sir. 99, Your Lordship. 99, running page, Your Lordship. 101. Paragraph 5 and paragraph 6, Your Lordship.
He also draws our attention to a coordinate bench judgment of this court in WPC number 3268 of 2011, dispute of White Order dated 22/4/2014. It went to apex court. Did it go?
Yes.
Yeah, very good.
Your Lordship, earlier they filed
Single line order was.
single note that was remanded.
So subsequently, it
Remanded this one.
after no SLP.
No, SLP. That has been implemented also.
First, lastly, he tells us that regardless of interpretations not to be placed on the text of the impugned orders, his clients would be satisfied if the benefit of regularization is, even if benefit of regularization is confined to determination and grant of terminal benefits, as directed by the tribunal itself.
SCP, MSCP and Pennsylvania.
First. Next paragraph. Having heard learned, kindly be seated. Having heard learned counsel for the parties and having perused the petition papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the reasoning in the impugned orders and the submission made on behalf of the private OPs. First one. We too express a few points for consideration. As I Roman 1-3. It is not disputed before us that all these private OPs are the employees of census departments headed by Registrar General of India. First term. Their services were engaged since 1980.
All are not. All are not 98. Initial appointment 80, 91.
There is a table.
Of different dates.
Different.
Their services were engaged on ad hoc basis
Yes.
as LDCs, lower division clerks. Subsequently, they came to be regularized with the condition that the benefit of regularization only for the post-regularization effect. Post-regularization effect. First.
96.
Some of employees elsewhere in other parts of the country had approached central administrative tribunals and had secured orders in their favor for counting the benefit of regularization with the effect from the date of entry itself. First one. The Bombay High Court in Union of India versus
D.B. Pandit versus Union of India. D.B. Pandit
in
page 63, sir.
one second. In Srimati D.V. Pandit and others versus Union of India and others. Has granted the relief as a paragraph 8, reproduce it as this. That is the first page 74. First, that being the position, the employees in Orissa who are in all force of OURS, similarly circumstanced for those in Maharashtra have been rightly granted the similar benefits by the tribunal at Cuttack. Next point. Learned counsel appearing for the private OPC is more than justified in drawing our attention to the office order dated 2nd April 2014.
We both had to 2nd April 2014.
Both dated orders dated 2nd April 2014, whereby the Bombay High Court judgment has been implemented subject to the outcome of review petition that was then contemplated. First time. On being asked, learned DST says he does not have any idea as to what happened to as to whether any review petition was filed, and if filed, what happened to the cell. First one. Had review petition been allowed, we assume, certainly that order would have been placed on record before the tribunal, before the High Court, or at least before us. First one. That is not the case. Once impugned orders are unconditionally implemented or implemented to certain conditions, certain contingencies, it is for the implementer to tell the court what contingency it was and whether such contingency has happened. First one. Next point. The vehement contention of learned DSG and also learned senior panel at council that post Uma Devi, there is a big shift in the law relating to regularization of services in public employment, and that the impugned judgments of the tribunal do not accord with that jurisprudence, comma, is bit difficult to countenance. First of all, it hardly needs to be stated that law as an institution of the society, as a social institution, is not a static water. Semicolon. It is more like a river Ganga, which keeps on flowing. Semicolon. Uma Devi is not the destination point. Semicolon. At the most, it was only a traveler's inn. Semicolon. Law has marched from April to May, and now to the June of its life, while the Chago and Dharma
Sripal
and Dharma.
Now it is
One more is there.
Yes,
Purana. Give that also, right? That right now. First, the rigors of Ruma Devi have been substantially withered away, comma, core remaining intact. First of all, therefore, Uma Devi would not come to the aid of petitioners. Kindly be seated. Next point. The last contained submission of petitioner's side that the tribunal's order has to be construed to the effect that the benefit of regularization of service has to be confined to determination of terminal benefits such as pension, etc., comma, is broadly agreeable to counsel for the OPs as well. First term. The tribunal has directed grant of ACP
and MSP,
ACP and
pensioner bill,
no, ACP one MACP. And it is only for the purpose of determining what the last pay run would have been on par with the other employees. First off. Therefore, any apprehension, comma, now does not obtain in view of this clarification. Next one. In the above circumstances, these petitions being devoid of merits are liable to be rejected, and accordingly they are, parts having been made easy. First one, we, by way of abundant caution, we make it clear that the benefit of the impugned orders is confined to the grant of terminal, which would obviously include ACP and MACP. First.
There's one university. They have conscious view by the Honorable Apex Court decision taken to by the what I have stated that 90 page 95, Core 7 2013, that all the persons directed to give the in view of the
Only they asked,
yes, yes.
there is no positive direction to regularize them with retrospective.
Before the honorable this honorable court position that on 4/7/2013 they have took a decision, the ministry, the regional, the registrar general, that took a decision to give all the ad hoc periods for the financial benefit. That has been quoted in the that is the judgment order.
Anyway, we have passed it, sir.
Yes, sir.
Okay.
Mobilization.
Yes. The order, when are you going to implement the orders of the tribunal? Again, one more round of litigation? No, wait on. The orders of, the impugned orders of the tribunal shall be implemented
3 months time.
within a period of, within an outer limit of 3 months.
Retired very. General retired very late.
Yeah, within 3 months, let them. If they do it, you should be happy. Yeah.
Mobilization.
Item number 6. First reference of SQL managed.
Ask, solve.
Item number 6. Item number 6.
Yeah.
Your Lordship has directed appearance of the,
Not you.
your Lordship has directed the appearance of the branch manager. He has appeared today. With regard to that forfeiture of iPads.
Because of Justice Chandrachud's judgment. Yes. You may be knowing everything about the case now. We had some suggestion last time we had put up. You have taken the possession of the property also. Because the client of Madam gave. Now you are in the possession of the property. Correct?
Yes.
What is that?
Yes. Possession has already been taken.
Taken.
Question is, your Lordship, that whether the refund of the 5 lakhs.
Yeah.
But we have stated, your Lordship, that the judgment is going to favor us. But one paragraph, your Lordship said.
We have pointed out one paragraph.
Extraneous conditions.
Yeah.
That extraneous condition will not be when there is a pandemic. That has been taken into consideration. But your Lordship said, I just read out the portion, your Lordship.
We are saying, you reconsider the prayer for recalling the forfeiture direction.
Your Lordship said, but I am just reading this, what they have said.
Keeping that in view. Now, otherwise, she would not have agreed for delivering possession of the property to the bank. Bank is in an advantageous position. Otherwise, you would have taken. When you understand these things, resist your temptation to argue and increase your temptation to do justice. You are a panel counsel. Now you have argued also. We appreciate that. Now possession of the property is taken, which otherwise would have been difficult for you, for at least for some period. Correct? Now there is one, if not a door open, a window not open, ventilator not open, but keyhole is kept open in that Justice judgment.
This court held that where the extraneous conditions exist, that might have led to the inability of the successful auction purchaser, despite best effort from depositing the balance amount,
Yeah.
to no fault of its own.
Correct.
In such cases, the earnest money deposited by such innocent successful auction purchaser could certainly act to be refunded.
Correct.
What we are saying is that she was capable to make the payment, but she has not paid due to certain, came to know that the suit is fine. But bank is also not aware about that. It is also not
Correct. What is her fault?
Miller, question is, due diligence has to be done prior to
No.
participating in the auction.
How they will know? In your state, that just I examine. In your state, suits relating to title are not reflected in the encumbrance certificate. In other states, they are reflected in the encumbrance register. Such and CS so and so is pending in respect of title to this property. They make it a note. That is absent. How many courts in the state? Hundreds of courts are there. You mean to say an auction buyer who wants to participate has to travel to all the court registers and get the information? Is it humanly possible?
I bow down. That is the question. But question is, if we are, when we are not known to the encumbrance and we have stated categorically, now this tag of title defect is also very difficult for the bank to resell it also. Now the entire value has been rigged because 2011 to 2016, 26, 15 years. Because of this, bank could not able to, bank has only got 2 decrees from the tribunal, that is recovery certificate. Now this decree will give an impediment whether it can be sold or not. It is very difficult. That also tagged into this property. Suppose tomorrow we'll go for a advertisement. The person who is come definitely will say that we have received the certificate from the tribunal. And as well as we have to mention that a decree has also been then whether his property is to be sold. So bank is not going to be benefited out of this. Your lordship to consider this much.
What she will do?
She will do.
Millard, she has just one reasoning, Millard. At that time, we could have sold it because she had raised this point after 5 to 6 months. And then we have said, no, there is nothing is known to us. And then
Whether you knew it or not, case was pending.
Case was pending. We are not party also. I have already stated for lordship. We are also not party to that. And it was not known to us. And had it been sold at that time, so bank could have not been put to all this position for 15 years to suffer. Now this property also is very difficult to sell
But
in the
these
market.
15 years is to be attributed
And also
to the
Supreme Court has
party.
also said, Millard, no sympathy and other things.
This entire 15 years is to be attributed to this party.
Millard, because of that, she was not allowing the bank to back.
And it is at our intervention on the other day. Kindly recollect. It is at our intervention on that particular day. You agreed for this. And we had insisted her to see that the position is given then and there.
Listen when judge speaks, listen. That courtesy shown to be judge.
So
How the position was given immediately on the very next day.
Millard, I bowed down. That was the favor because of this court's indulgence. We are
It is
not
because of that reason that we will show something to her.
So your lordship, that is because they are saying if it is
And we have seen in other cases also, bank has refunded. We have passed many orders.
Bank has got the property and possession, but it is now very difficult to sell it. That is the only question. And even if Supreme Court has said, Millard, even if it is sold, it will not be unjust to enrich the bank by taking this money.
No, that part is.
And equity also does not demand that money should be paid to her. But if it is to be done, then it will be a precedent. Everybody will
say that it will not be a precedent at all.
That
will make it clear.
So, your lordship, that if 5 lakhs, the property value at that time was 23 lakhs. If your lordship see the time value of the money, at that time 20 lakhs, if you could have sold today, what my branch manager said, it may fetch hardly 25 to 30 lakhs. If you could have got 20 at that time, it could have been 15 years, it could have been 50 lakhs or something on time value of money. So considering all, this has a loss cost to the bank because of bringing up the value.
What loss cost to it? Suit was pending.
Then suit was
Even when
Millard,
action took place.
Millard, suit was pending, but were not.
Your ignorance cannot be a matter of benefit to yourself. Ignorance is bliss where it is folly to be wise.
Millard, when mortgage was there was no suit. It is very categorically.
Yes.
Suit was in 2007.
Who said?
Mortgage was created in 2004.
We don't.
So, I have just bowed down before lordship.
What is the value of that property today?
It may be around 30 lakhs, he is saying. They have not done the valuation today, but maybe very old flats. It is fast flat perhaps in the Cuttack, and it is very dilapidated conditions. It may not fetch more value. Or
How many flats are there?
How many flats? It may be 20, 30 flats in the entire apartment
Area.
in apartment.
No, which area?
The Professor Padakkota, the old building, and it is very dilapidated condition.
No, but the area is
It is good, but it will go for suppose in further auction. It may not fetch the amount what we were expecting to get at that time.
One second. You were in the possession of the property. Did you pay the rent?
Yes, my lord.
To whom you have paid?
I was paying the rent to the owner, my lord.
Show that.
This is, at present, this is not with me, my lord.
You bring the receipts.
I do file. My lord, one thing. My
All
lord.
right. Do you suppose if you are holding the property without paying rent to him, not to the bank, because all these years you have been holding the property, you show us your bona fide. We are in the writ court.
My lord, at Annexure 7, page 87,
The petitioner to vouch the claim that he has paid the rent for retaining the occupation of the property now in the possession of bank. Now in the possession of the bank. So that equities can be adjusted. If equities, if any, can be adjusted with that voucher. First one. Call this matter non-vouching may affect merits of the petitioner's case. Call this matter week of election.
Item 2.
May I please, Your Lordship?
That's fine.
May I please, Your Lordship? Not, I am in virtual mode.
Yes.
So in this case, the petitioner challenges the illegal selection process for the post of Gramin Dak Sevak for the branch of Post Master Milord, and this before the Learned Central Administrative Tribunal Milord, and the Learned Tribunal below dismissed the petitioner case solely on the technical ground for delaying in filing the original application, though he has submitted all the reasons why he has delayed in the matter, Milord. In this case, Milord, the OP number 4, Milord, why is notification invited application in a prescribed format, Milord, for the post of that Gramin Dak Sevak branch postmaster, Milord, and accordingly, the applicant and OP number 5, they have applied for the said post, Milord. The authorities overlooked all the false information furnished by the opposite party number 5 regarding his date of birth, false mark sheet and residence, which is in clear violation of clause 10 of that notification, Milord. The petitioner made complaint on 29/2019 before response 2. And then, Milord, when he received no response, he also made an appeal on 18/3/2020. But due to the breaking of pandemic, that corona, Milord, no effective action taken for the whole year. So he made a reminder on 24/2/2021, Milord. And then he filed before the Central Administrative Tribunal the original application, which was dismissed that it was only, they did not want to consider the delay caused by the petitioner filing the original application.
Come to para 12.
Milord,
Para 12 of the judgment.
I mean, pardon me, Lord. I am out of station, so I could only collect the PDF of my writ petition, Lord. If I Lord keep it on after 19th, I will be available at Cuttack, Lord.
But don't, after arguing, generally we will not entertain any request for adjournment. As an exception, we are doing that now. Since you were traveling, you said, yes, 2 weeks.
Item 3.
Subject to condition, next time we shall not repeat the same argument.
No, I am highly obliged, Lord.
Next.
Item 3.
That's a mistake. Actually, your Lordship has referred to the order, the Lordship's order dated 3/2/2006. Lordship referred to 882 of 2024. That is some other case. Actually, 882 of 2004. And para 9 should be.
What is that number?
882 of 2004. No, sorry, 2024. I filed that judgment also in my para 9 should be quoted. The Lordship quoted the impugned judgment.
No. In place of 882, it
should be 882, and para 9 should be in place of this quoted person. Para 9 should be quoted. The Lordship kindly see that order. This is related to some other land matter.
Number, that case number is different.
Number is different, and the order of automatically the quotation portion also different because of that. It's some related to land matter. 882. My actual case is impugned judgment is 882 of 2024. Judgment date is correct. Date of judgment is 15/4/24. The Lordship kindly see the impugned order. And I also filed that impugned order again for Lordship's convenience. Please stay in your Lordship kindly.
Which paragraph is
only this first para, the code by the WPC 882 of 24, that should be 882 of 24, and the quoted portion should be replaced by para 9 of the 882 of 24. I filed a copy of the judgment also for the Lordship's convenience along with the IA.
An application IA number so and so supported by affidavit is moved, pointing out the mistake committed by the court in quoting WPC number 882 of 2024 instead of
888 of 24, 888.
instead of WPC 888
2 of 24.
2 of 2024, which was disposed of on the very same date when the other case was disposed on. First time. There is a force in the submission. First time. Anybody opposing this? Who opposes for the other side?
State.
State, they don't oppose any state. Yes. State.
Quotation portion should be para 9.
Entire para 3 to be replaced now.
By para 9 of the 888 of 24.
There are 9 of 882 of
24. That is at page 14.
2024 to be quoted where?
To quoted here, the quoted
In the beginning part.
In the quotation part. In the following terms.
Yeah.
So the relief has been in the following terms. That will.
Therefore,
Para 14, page 14 also.
the first paragraph of the order to be replaced by paragraph 9
9. In
of
WPC 2 of 24.
882
Of 24.
of 2024. Just after that, please send your colleague along, government advocate also. Both of you have to come to chamber because if we do the mistake, we'll draft it. Thereafter, just you see whether it is correct or not. Then we'll finalize.
I'll ask my associate to be there.
Right?
I'll ask my associate to be there.
Yes, both let them come drafting our lenos. And then
Around 1 o'clock will be sure.
Yes.
Item number 4.
Ordered according to yeah.
May I please, Your Lordship?
Yes.
My lord, there is error in the cost title of the order dated 21st January 2026. Here the name of the respondent representing as Ranjan Kumar Raut instead of Krishna Chandra Behera.
What to Behera is not the respondent.
No.
Respondent is who?
Actually, respondent is Krishna Chandra Behera, but name is reflecting as Ranjan Kumar Raut.
Name of respondent to be changed as
Krishna Chandra Behera.
Chandra Behera.
Reflecting as Ranjan Kumar Raut. It should be replaced.
Removing the present name, that is
Ranjan Kumar
Raut. Rectification granted. Yes.
Item 5.
Issue fresh
Lordship may kindly see the defect pointed out by the SR. Staff reported that the writ appeal is not maintainable. But inadvertently, I have not challenged the main order. I have only challenged the review order. Now I have filed IA number 4588 of 2025. Perhaps that has not come.
What?
For amending the writ appeal in order to challenge the main order.
Post along with other IA.
Yes. IA number 4588 of 2025.
Number
4588 of 2025.
25. We got next. Yes. Okay.
Item number 6 has been adjourned. Item 7.
Yeah.
The present petitioner, the legally married wife of Raghunath Mali, and OP number 4, who claims to be the wife of the Raghunath Mali, filed original application before the Central Administrative Tribunal by inflating the present petitioner as party and the tribunal without issuing notice and serving copy, my lord, to the petitioner and verifying the records that whether notice has been served to the respondent opinion present petitioner, passed the impugned order in favor of the OP number 4.
The coordinate bench.
My lord, no, it is Central Administrative Tribunal. Order of the Central Administrative Tribunal is order challenge before your seat.
But there is an order dated 23/9/2024
My lord,
made by the coordinate bench.
my lord. Coordinate bench directed to verify the whether notice has been served. The 10/9/24 your lordship order, kindly see 10/9/24 your lordship order.
10/9/24.
10/9/24.
That also coordinate bench order.
My lord. In that order, this honorable tribunal directed the registered Central Administrative Tribunal para 5 to whether notice of the petitioner respondent for has been served, made sufficient or not.
Then go further.
My lord. The petition,
No, registrar's report has come.
my lord, your lordship last occasion verified and thereafter notice was issued. Actually, notice was not served, my lord. The present petitioner while deciding the matter. My lord, 21/10/86, the husband of the petitioner, present petitioner, Raghunath Mali, initially joined as accountant in the office
When
of
he died, you tell. It's a compassionate appointment, no?
Miller.
No.
Family pension.
Family pension. Pension is sanctioned now.
Yes,
Pension,
ma'am.
pension is sanctioned in OP number 4.
OP number 4.
My lord.
She is another lady.
Another lady, second.
First lady's marriage happened when?
9388.
1988.
88. With the present petitioner. Thereafter, my lord, in 8990, the husband of the present petitioner, in 8990, my lord, the
8990.
90,
Second marriage.
no, the husband of the petitioner nominated the name of the petitioner in the GPF nomination form, retirement gratuity, death certificate nomination form, benefit under central government employee.
That's the wife.
That's the wife. Present petitioner is the wife. That is 8990, Annexer 1 series. And in that Annexer 1 series, my lord, the senior account officer put his signature and other 2 officers of the office also put their signature.
It is attested.
My lord, that
Attesting witnesses are there.
witnesses. My lord, on 24/9/98, the petitioner filed a case before the Chief Judicial Magistrate Ranchi, Chief Judicial Magistrate for maintenance.
Was it under 125?
My lord. In that maintenance case, my lord, the husband of the petitioner admitted that the present petitioner is the legal married wife and he's never kept any, he's never married second wife. He admitted in Annexer 4, that is Annexer 4 of affidavit of the petitioner's husband. Annexer 4, page 26, your lordship will kindly see. Marriage was solemnized, he has admitted that. Page Roman 2, my lord.
CMC
35 of 1998.
CMC 35 of 98.
What happened? What order was made on there?
And their compromise was made, and thereafter monthly maintenance was given to the petitioner.
Where is that compromise order?
Compromise order is not with me, my lord, but they paid me, the husband of the petitioner paid me the regular money order, sent the regular money order.
What order was first on in the CMC?
CMC that was compromised and dropped.
No, what is
the
the
order?
Order will lordship kindly see, another order was passed by the that is page 44 annex 6. That is Court of Additional Principal Judge, Additional
Withdraw
Family
all
Court, Jamshedpur.
You are not answering.
My lord,
You are not fair to the court.
I'm sorry.
What happened to CMC 35 of 98?
That was, I have mentioned that on a compromise, that was case was dropped.
Show that.
order?
Order was not with me, my lord.
Do you have the order?
Thereafter,
Their case I have not party there. I am appealing for
another order is there, another order,
wife.
compromise order.
Married
is there.
wife.
OP5.
OP4 man.
4.
Another order of compromise order is page 44.
No, that is all right. That is in different court.
Different court, my lord.
But what compromise were entered, basing on which you were allowed maintenance?
In para 4, I have mentioned.
Counsel filed by the accountant general on behalf of accountant,
Annexure?
annexed the day.
You are side. You are from the side of accountant general.
1, 2, 3, opposite matter. 1, 2, 3.
What they say?
The Court of Additional Principal.
That's all right. What is the gist of that?
Allowed to pay 7,000 rupees monthly.
To OP number?
To petition.
To petitioner. What is the actual amount payable?
Nothing has been paid.
No. They paid me till my lord, Corona period, 2019. After Corona 2019, they did not pay. And notice was issued by the Law and Court under Annex 7 to make payment.
And there's 7.
My lord. Court of the Additional Principal Judge, Additional Family Court, page 45, my lord.
In another CMC.
In another
Miscellaneous case.
Miscellaneous case 147 of 2016.
16. Earlier was earlier CMC was
35 of 98.
98, and this is in 2016.
In both the in 147 of 2016 and both the case, the husband of the petitioner admitted that the present petitioner is legally married wife.
Did you raise any issue as to second marriage?
My lord, they have denied that they have not married the second marriage. Even though I have
What is
stated,
that?
I have only that they is living with some person without any marriage, my lord, some lady. But they admitted that they have no relation in the first case.
That lady also admitted.
No, lady saying that OP4 saying that I am married subsequently. They are married. But during the lifetime of first wife.
Whether she was a party.
In this case, he was party.
In that case, she was a party.
My lord.
In miscellaneous 146.
No, in the miscellaneous he was not party. At that time, I have no knowledge because he denied that he was never married to. He denied. He lordship kindly say Annex 4. He denied I have not kept any. Never married.
Where when the second marriage took place?
Neither the applicant, the OP number 4 before the tribunal, nor here. They stated any single sentence when he married to the husband of the present petitioner. Not a single statement. Neither before the tribunal nor in the counter before this annual court.
You were party to the tribunal.
I am party to no notice was not issued to me nor not served.
No notice was issued.
Notice was not served to me. And the expert order was passed by the tribunal.
Is it true?
No, I made her as party. Notice issued.
Notice was issued.
Yes, my lord.
The other side.
Notice issued.
Served.
Because she was a party there.
But she served.
Not only my lord in the way, also I filed an execution in.
Has it been served? Even if you made her party, whether it has been served?
Your lordship asked for a report from the registry of
What is that report?
CAT, my lord. That
What is
report is
that?
available with my lord.
What is that?
Regarding sufficient of notice on the petitioner.
Notice was not served.
Not served.
Whether you are a voter.
My lord.
Telling me your language.
You have not, were you in your place and it has not been served?
Not
What
served.
was the address given in that application?
Address given, but
That was the correct address.
Yes, ma'am.
but no register letter dispatched, my lord.
The report
The
of
word of
the-
dispatch is nothing mentioned in the registry by the tribunal.
Where did your client marry?
My lord, I have no knowledge because So far my status is dispute concern, there is no dispute, my lord.
No, we are disputing now. When the marriage took place,
So,
where it took place, who attended?
There is no such pleading available in the way or on say counter, my
No,
lord.
you have to say. You went there saying that I am the legally wedded wife.
Because
You should have pleaded those things.
Because my lord, my name appearing in the PPO,
Huh?
pension payment order, my name is appearing as the wife. PPO issued in my favor, my lord, as the legal matter wife by the departmental opposite parties, my lord. There is no dispute to my status, my lord.
On what?
And nobody is challenging my PPO, my lord.
We are here to do justice. Well,
submitted by the petitioner, this is the employee. Showing that the
he died on which date?
Purnima Madi is the.
He retired on
31st January 2018, my lord.
And died on 23/3/22.
22.
retired on
31st January 2018.
2018.
18, my lord.
died on
23 March 22.
after his death. Did you dispute the marriage?
My lord. My lord.
After his
My lord.
death,
My lord.
did you
I am
dispute the marriage?
My,
Well,
because our husband, my lord, my husband himself admitted that he never married.
so you did not dispute. That's quite a difference. So our question was that you have not disputed.
Because no marriage was solemnized. And as admitted by the OP4 before the tribunal and here.
Before admitted there was no marriage.
No date was mentioned when he married. No date. She married.
So the claim of this so-called second wife is only on the basis that her name appears in the PPU as wife. So receive
This is the
no other document, no date of marriage,
That
nothing.
pension is paid to whom now?
Nobody is receiving.
Initially that has been sanctioned in favor of the Purnima marriage. After disposal of the original.
Name we don't know. OP number you should say in.
OP number 4 or the petitioner?
Four.
OP number 4.
So you are receiving.
After filing of the writ application for lordship, the pensioner will stop.
How many months it has been paid?
How many months he has received?
Only 1 month, my lord.
Only one.
1 month. What the learned singer? Is it a learned singer? It's not a what?
No, it is cat's order.
Cat order.
Cat order.
State order.
Basis of the cat order.
What cat said?
my lord, cat says, my lord. The dispute between the government servant Raghunath Mali and Sumitra Devi. The present petition was not a party before the Jamshedpur court, my lord.
How long your name appeared in the service register?
No.
As a spouse.
In the initially, my lord.
How long?
Your lordship, 8990. In 8990,
Till
next one series, my lord. In the GPF nomination form.
No, your marriage happened on 9/3/88.
My lord.
After employment or before employment?
After employment, my lord.
He joined on which date?
21/10/86.
21/10/86.
1986 joined. My husband joined. And marriage was solemnized on 9/3/88.
9/3/88. Where it was solemnized?
Marriage between petitioner and Raghunath solemnized as Muri, P.S. Silli in the district of Ranchi,
Puri.
in the state of Jharkhand.
Jharkhand.
Mine.
Both they belong to same community.
Mine.
No.
I am belongs state of Odisha and Odia. She belongs state of Jharkhand and
No. The petitioner
Both
is also from Jharkhand.
Jharkhand.
both did you go to any grammar school throughout your life at any time? I am asking, both do they belong to the same community?
Community.
No,
Is
my-
it true?
No.
No, they
Yeah.
don't belong to the same communities. In your case also.
Mine.
They are intercaste.
Are they intercaste?
No, I have not asked him for caste so far as
You are not sure.
that.
No, you are not sure whether they belong to the same community or intercaste.
I have not known knowledge.
The disputed fact is that two legal hair also there.
8990.
No, legal pension does not go to legal heirs. It goes
8990.
to spouse.
Marriage. That is both of they are two wives. Together.
8990, my lord, after the marriage, my lord, the petitioner husband nominated my name and duly signed by the officer of the AG office, my lord.
And that was carried since how long? This nomination
Till 2013, my lord. After 2013, the name of OP4 was
Central government employees also.
Separate accountant.
No, your name appeared in the service register as a nominee.
Recording in progress.
Dropped from the registry at what level?
my lord, during 2019 Corona.
Who is your opponent? Who are the parties? Accountant General, Senior Accountant Officer.
who is your employer?
Accountant general.
Accountant general.
Open number
Union
two.
government.
Open number 2, man.
Who appears for the Union government?
Only.
No, we want to know. See, after 1988, March 1988 marriage, her name came to be entered. At what point of time name was deleted and other lady names came there? That we want to know. Once name is entered as the spouse, to remove that name, only two things, either divorce or death of the spouse. Except these two, some other lady cannot enter there. Otherwise, the very purpose of nominating a particular spouse for pension purpose will be defeated.
If Lordship pardon me, I can place the record. The document, page 48, my lord.
Which department, brother, your client is, your client's husband was?
My lord,
AG, in the office of AG, Accountant General.
The Accountant General.
In the office of the Accountant General?
My lord, my submission, the statement made by my lord and friend that the name of her client was inducted as wife of the deceased employee is absolutely false, my lord. Your lordship kindly give a glance, page 48.
How? Why false? But there are two attesting witnesses.
No. What submission, what document he himself enclosed, page 48.
Page 19.
Page 48, my lord. First, lordship, can give a glance, page 48. Then I will place the counter, para 18 of the counter of the department of the opposite parties, my lord. Page 48, my lord. This is whole document. Issued by the department. Last para, my lord. Last part. One sub para.
2023, my lord, after the death and return.
I am placing the contents of that letter, please.
It says office is not aware of the existence of another wife.
My lord.
Because that was removed.
For the government servant during that. Who was your, in which office husband was, the person was working?
Office of the Accountant General, A&E.
Accountant General.
The employee of the accountant.
See, now we want to know, after so-called 1988 March marriage, whether entry was made in the service register.
Employee made in
the employee.
OP4 record is there.
Not OP4. Employee, he gained employment in 1986. He married in March 1988. Correct. He retired on 31/8/2018. Died on 23/3/2022. Correct. So after he gained entry. There is a spousal column in the service register.
There is nothing available in the office of the accountant.
Why?
How to do?
How can that be?
Copy number 4 is there.
On what basis?
When they submitted the pension paper by the deceased employee, the record is there.
Will you not look into the earlier entries in the service register? Whether some other person's name is appearing, whether this person is naming some other person, will you not verify that?
I verify. Any other day, I will take instruction on the matter.
But it is never heard of that a person entries in employment and his service book is not there. And it doesn't appear there.
You produce the service book.
Yes, ma'am.
How?
Yes, sir, ma'am.
What distance? Bhubaneswar. We'll call this matter tomorrow. Next week. Call this matter next week.
Contempt proceeding is on the basis of contempt, the opposite party is going to release it.
I have filed a IA. This is something MA filed before the Central Administrative Tribunal. The tribunal has passed an order to immediately disburse the amount in favor of the
OP4.
Say that. We want to know. What are the material to show that you are the where marriage took place, etc. Your voters list, a Gram Panchayat record, these things you produce.
Yes, my lord, I will produce all these documents.
Since matter involves rival claim as to the petitioner and OP number 4 being the spouse of deceased employee, both are directed to produce evidentiary material to vouch the performance of marriage ceremony and other collateral evidentiary material such as voters list, ration card, service register, or court records, if any, on the next date of hearing. First off, the official OPs are directed to produce the entire service record of deceased employee that
Raghunath Mali.
For the period between entry into service, date of entry into service and his superannuation on 31/8/2018. Right, you produce everything.
My lord, the contempt proceeding may be stayed so that.
In the meanwhile,
my lord, I have not filed any contempt. How my lord can know that?
In the meanwhile, if there is any contempt proceeding, the same is stayed. All right. So that we know who is the true wife.
Because the petition is at Jamshedpur, some more time has to be given.
All right, 3 weeks. You give a date up to 3 weeks so that it becomes easy for them. Yes. Next.
Item 8.
Yes.
Item 8, Miller, is a state appeal. Batch of cases arising out of one judgment, which is of undated Miller 26/4/2024 at Annexer 2 at page 35. Before my lord coming to the case last occasion, my lord has directed my learned seniors relied upon one judgment of this Hon'Ble Court, whether this case is similar to them or not. That is a pharmacist and mobile health unit, Miller.
Pharmacist.
In the case of Chabindra Kumar Samal, my lord, judgment of this Hon'Ble Court. My lord, I am only can substantiate with 2 points, my lord.
What is the relief granted? Why they were before the learned single judge earlier?
Regularization.
Regularization.
Yes.
Well, what is the length of service they have put in?
My lord, so far the present petitioner is concerned, my lord. He was since 25/4/2017.
25/4/2017.
I am holding the first brief.
In the rest of the cases, which is the oldest case? Oldest, longest service?
My lord,
2011.
my lord, in some case, 95 onwards, the up to 2014-15, and the statutory rule came into force, my lord. My lord, the rule says, my lord, or regulations.
Yes.
Same.
Put a Hon'Ble brother.
I would have copied.
Whether identical case is treated by the court bench.
We say that is identical. It's according to us.
Even the government council and the conducting council are also saying.
Mr. Sao is there, Mr. Sumanthi is also there.
I can advance only 2 points, my lord.
Yes.
I will not waste my lord's time.
Yes.
In fact, so far the service condition is concerned, my lord, there is a rule. Odisha Pharmacist Service Method of Recruitment and Conditions of Service of 2019.
2019 rule.
Yes, ma'am.
But they gained entry before promulgation of these rules.
My lord, the present petitioner is of 2017. Others
Therefore
are
obvious.
My lord, then the amended rule come in 2020. My lord.
2019 rules are amended very next year.
Next year, 2020.
What the original rule said, what the amendment says.
Exactly. So far the amendment rule is concerned, my lord, 2020. Can have a glance to Annexure 3.
We'll
At
put the original rule.
Then original rule
So what they want
is at Annexure 6 in the REIT application, page 43.
6. But these rules are meant for direct recruitment.
That is rule 4, my lord. Can have a glance.
Conditions of taking over of existing contractual pharmacy.
Exactly. Exactly.
Those persons only.
Those persons. May I read it more?
The data comes to those. All the society schemes. 6 years of that contract shall be deemed to be regular government employees.
Subject to?
They are deemed to be government employees.
Yes. Deemed to be government employees as a one-time measures.
Yeah.
Subject to fulfillment of eligibility criteria as prescribed under Rule 5. Coming to Rule 5, the next. Modalities for induction of pharmacist into the cadre. Romani guy, such pharmacy who have the minimum educational qualification and other eligibility criteria as per Rule 10 at the time of engagement under the society oblique scheme, who has been selected through an open and transparent recruitment process. Then 3, while inducting, the prevalent reservation principles in Rule 6 shall be followed. Then Rule 6.
What is meant by? While inducting means what?
Inducting to the regular cadre, my lord.
Inducting to the regular cadre because prior to that, they are contractual.
Contractual in scheme.
4 says about the conditions taking over the existing contractual pharmacist, subject to fulfillment of the conditions. I am reading Rule 6.
But heading is not correct. It is not taking over. It is a deemed to be.
Yes. Deemed to. That was decided by Hon'Ble Appeals Court.
That is also reflected so far the judgment which is relied upon, that is Amit Mishra. That is also, it has been categorically stated, it has not been happily worded. The word is
Anyway, we are also not happy with this. Anyway.
That I cannot develop, Mela. So while inducting, the prevalent reservation policy as per Rule 6 shall be followed. So that means 3 things, Mela.
What is meant by inducting, we are unable to understand. Rules do not appear to have been written by a person from the field of law.
Before that, no rule, my lord.
There was no rule.
No rule.
No, why he is using the word inducting? Where is the induction? There is only deeming.
Or we have heard about absorption.
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 This is not a case of absorption. It's a deemed to be. Deeming has been explained by the Apex Court from 1951 to 2002. There is a famous book also by Raghavachari, Law of Fictions. Very beautifully written book. Anyway, then.
My lord, then coming to the new rule, my lord.
Yeah.
In 2020. It is available at Annexure 3, page 103. This amended rule, in Rule 2, in the Odisha Pharmacy Service Method of...
One second. It referred to Rule 10, na?
Rule 10.
It referred to...
At page 46.
Rule 10. Let us go to Rule 10.
Exactly. Rule 10.
Yeah.
Rule 10 is the qualification which has been prescribed. That is the minimum qualification. The educational qualification of the candidate for the post of pharmacist shall be as specified at column number 4 of the schedule.
No, this is for regular recruitment.
That word is inducting.
No,
and
10.
The person who have completed 6 years, I'm coming to 6 million on conjoined reading million. It cannot be read isolation.
6.
On the date of commencement of these rules, that means in 2019, all the contractual pharmacists who have been duly recruited by the concerned society oblique schemes and have completed 6 years of satisfactory contractual service shall be deemed to be regular government employees as one-time measures subject to fulfillment of the eligibility criteria as prescribed under Rule 5.
As prescribed in Rule 5.
Rule 5.
We do not travel to other rules at all.
Yes. Because Rule
Other
5,
rules.
other rules.
To direct recruitment.
No, ma'am.
Kindly come to Rule 6.
Yes, ma'am. Yes. Method of recruitment.
Yes, really.
Subject to other...
It's the rule.
Yes.
6, 7 maybe.
And
6, 8, 9, 10.
8 is there, my lord.
Yeah, 8 to 8 applies to everybody now. We'll assume that way.
Yes, ma'am. And 10.
Up to 10.
Up to 10.
10, 11, 12. 6 to 12. These people are not within the framework of 6 to 12 at all.
Exactly.
When you go for direct recruitment,
Yes.
these rules.
These rules to follow.
For them, what is applicable is Rule 4 alone.
Alone. Yes.
Subject to
that has been
qualification.
Exactly.
In schedule.
Yes.
Qualification in the schedule. That qualification they should have. That's all.
Exactly.
That's what you are. That's how you are reading Rule 4.
Yes, my lord.
Yes.
My lord, then coming to new amended rule of 20. This is at Annexure 3, relevant pages 103.
Annexure 3 of writ.
My lord?
Annexure 3 of writ appeal.
Writ appeal. I'm reading 2.2. In Odisha Pharmacist Service Method Recruitment Conditions Service Rule 2019, hereafter read as the said rules in Rule 4, Sub-Rule 1, excluding the provisos, the following sub-rules shall be substituted, namely, on the date of commencement of these rules, all the contractual pharmacists who have been duly recruited by the concerned society or scheme for working in different fixed healthcare facilities. It was not in the 2019. Different fixed healthcare facilities. They have been appointed in 2 settings. One is mobile healthcare unit, another is a fixed healthcare facilities.
What is meant by schemes?
Schemes. Well, that's a mobile health unit.
Proviso 4 million. Page 44. Provided further that those contractual pharmacists who do not meet the eligibility criteria as mentioned in under Rule 5 shall continue as such under the OSH and FW Society till closure of the project, retirement or disengagement, whichever is earlier.
What is OSH and FW?
Orissa State Health and Family Welfare Department. Health and Family Welfare.
If project comes to an end, their employment comes to an end. That way.
O terminus. So far this 2020 rule, my lord, it came into force on 27/11/2020. While considering the case, the earlier case which is relied upon, that has not been taken into consideration, nor when the Amit Mishra judgment of our own tribunal as well as the High Court and before the Hon'Ble Apex Court. This has been decided in 12/1/2021.
Subsequent to amendment.
Subsequent, but this has not been taken care of.
What we can do? You mean to say, who argued the matter from your state?
And the very amendment was never challenged by any of the party. Can I have a glance to the order of the Hon'Ble Apex Court in that?
Nowhere it says anything about the amendment.
No, my lord. I'm serving this opinion. That been dated 12/1/2021. And the WPC was also disposed of prior to the amendment.
What this in Chabindra Kumar Samal?
Your Lordship have dealt that in para 7.1.
That argument you have.
Yes. 7.1.
Whether amendment is taken care of?
No.
Well, Lord,
so far the 7.6 is concerned. But so far the Amit Mishra judgment, my Lord, may I give a short clarification. Amit Mishra judgment from this our state, my Lord, the OA number 744 of 2017, my Lord. Then WPC was filed 1353/2020. This was disposed upon 3/2/2020, my Lord. And the SLP was disposed upon 12/1/2021. So far, this writ application is concerned of this Hon'Ble Court. This was prior to amendment, that is 3/2/2020, where amendment was taken place on 27 November. It was in the month of February when the writ application was disposed of.
What is meant by MHU pharmacy?
Mobile health unit.
Mobile health unit.
This is a schematic post, my lord. Under the National Health Mission, there are several schemes are operating under the Health and Family Welfare Department. MHU and RBSK, these are the schematic posts. These are the schemes floated by the government different times. And this rule is only meant for one-time regulation. That is why I was on my lord, in both the cases, not only the Amit Mishra case. Last year, on 16/4/2024 also, Honorable Apex Court dismissed another SLP. I have given the Lordship last date, I have given the Ashok Kumar Sau's case. That was also the SLP prepared by the government. And the same argument was raised. I was on the VC, my lord. That was discarded by the Honorable Apex Court. And also implemented and benefit were extended. And now say they are segregating that the same mobile health units and RBS those cases. 5 districts has got the benefit and the other districts they are now.
Mohanty, how amendment would change the substratum of our judgment?
That is the exact amendment. Deeming provision.
There is amendment. How that is going to change?
So far the latest Supreme Court judgment is concerned, so far the Amit Mishra which is relying upon, therein amendment has not been taken care of. Because in the writ application.
Assume that now amendment is there, na?
Yes, ma'am.
Amendment.
Yes.
When it was published in the Gazette?
It was published in Gazette, my lord, in 27/11/2020. Yes.
When were made available to the public?
Same, my lord. 28.
Made available to the public?
28. 28/11.
They were made available to the public?
Yes, my lord. In the public domain.
It's in the public domain only.
Yes, ma'am. 28, the next day. And the writ application was, but this writ application was filed, which has been taken care of. Kindly have a glance to page 40, para 47 of the judgment. 47. It is at page 100.
When the judgment was rendered, amendment, there was already amendment.
Already amendment.
And that was taken care by the...
Page 40, para 47. Para 47, page 100.
Has already been observed.
Exactly. Writ petition was filed prior to amendment of the rule 2020, but it's not effective now.
That's wrong.
Yes. Why I am saying,
Date of
kind of a glance to 105 page.
105.
Yes.
Let us ask them whether when you had filed the writ petition.
I have given the details. I have given the data. 105. For a moment. Let me clear. It is a matter of document.
Dealt with that. When it was filed.
105. The case type, file number, registration number 34165. This is the date of filing is 1/11 and it has been registered on 2/11.
So after the amendment.
Exactly. But 47, so far this observation is concerned, the writ petition was filed prior to amendment. This is not correct to me, my humble submission.
My lord, para 45 of the Honorable Single Judge.
That come to you. Will come to you. Wait. Otherwise, he will be disturbed.
My lord.
Yes, sir. We can disturb him, not you. Mr. Mohanty,
Hey.
which cases were filed prior to amendment and which post amendment?
Yes. Millard, there are around the 60.
83.
Some of the cases of 2021 as it appears, some of the cases in 2020, my lord, as it appears from the cost title, which is at page 35 and 36 of the judgment.
Whether what is the impact of amendment on the judgment that was rendered without referring to that amendment? What the amendment says actually?
Amendment says only it is in respect of the different fixed healthcare units, facilities, I mean corrected, facilities, MHU, which was not originally in the 2019. So far the 19.4 is concerned, can have a glance for a moment at page 44. The language is, on the date of commencement of these rules, all the contractual pharmacists who have been duly recruited by concerned society / scheme. Pause for a moment, Milo. Then coming to 103 page, so far the amendment is concerned.
103?
Yes. On the date of commencement of these rules, all
On
these...
the date of commencement of these rules.
Right. On the date of commencement of these rules, all the contractual pharmacists who have been duly recruited by the concerned society or scheme for working in different fixed healthcare facilities. This different fixed healthcare facility.
The date of commencement of these rules means what? Well, principal rules or amendment rules?
Principal rules of 2019.
That rule only.
Yes.
So your whole submission with regard to the amended provision is only to put a bar on those who have who are working in mobile.
Mobile, yes. Fixed healthcare.
That is your case. That is not the notification.
Fixed healthcare, not MHU. Fixed healthcare.
That is what you mean. The regulation is only for fixed, not for the mobile.
Image.
But they would have said it.
How does it exclude that?
That is the rule, Milord.
No. You see, start section 2.
Yes, ma'am.
And then come to 1.
Yes, ma'am. Orissa Pharmacy Service Method of Recruitment and Conditions of Service Rule of 2019 referred as said rule, Rule 4, Sub-Rule 1, excluding the provisions, provisos. The following sub-rule shall be substituted, namely, on the day of commencement of these rules, all the contractual pharmacists who have been duly recruited by the concerned society or schemes for working in different fixed healthcare facilities only against the post approved or sanctioned.
Only should be
different
post fixed to healthcare facilities only.
Yes, ma'am.
That way.
Different fixed healthcare facilities only.
Pension to the government or action plan or even and have completed 6 years of satisfactory contractual service shall be deemed to be regular government employees as one-time measure, subject to fulfillment of eligibility criteria as prescribed in the Rule 5.
Rule 5 of 2019.
By date of the order, you have already implemented. By date of the 19 order, the matter which has also traveled to Supreme Court has already been implemented, as you say. Has it been implemented?
All the orders. In respect of Sundargarh and Sambalpur, Rayagada and Balangir, they have extended the benefit from the date of completion of 6 years of service. Well, when the Rule 419 rule says that deeming provision, that was taken care by the Honorable Apex Court. So on that date, when everybody has been regularized by treating them as a government servant on view of the deeming problem, what is left for them to debar them after 1 year? When by that provision we have been deemed to have been regularized, is there anything left for them to exclude us after 1 year, my lord? That was the same argument they have raised before the Apex Court during my lord. I was also in the council, my lord, before in the BC, and the same argument raised.
We don't make all that sense. We don't ask. We ask the judges to vouch here by filing affidavit. We go by what the record.
My lord, my lord.
Who appear, who wear long band, short band. We do not know all that. We will see the record and decide the matter.
And the last year also.
Mohanty,
My humble
what is
contention
the impact of amendment?
exclude color. This has been excluded. My lord, once again I am reading that language. Method of conditions of service rule 2019. Hereinafter I said rule. Rule 4 for sub rule 1, excluding the proviso.
Provisos.
Yes. The following sub rules shall be substituted, namely,
That means substituted means
that proviso
taken and put into the body of the 2019 particular rule, excluding provisos.
yes.
That means for the substantive rules, this should
That it is construed from the amendment itself. It's clear, my lord.
there shall be a competitive.
Excluding the provisos. So in the proviso, it is a deeming clause. Provided that all the contractual who are yet to complete 6 years and rule 5 shall be deemed to be contractual government employees. That is the proviso.
What is that rule 4?
Subclause 1
Huh?
is 42.
Sub-rule is not changed.
Sub-rule 1.
Sub-rule 2 of rule 1 coming to force and so in that is sub-rule
1 minute.
no rule 2 itself. Sub-rule 1 of rule 2.
Sub-rule 1 of rule 4 minute.
Rule 4.
Yes, ma'am. Page 103.
State rule. In rule 8, after sub-rule 4, the following sub-rule shall be inserted, namely, in the state rules. The 2020 amendment you are reading now.
Yes, yes.
Rule 4 of 2020 amendment.
Yes.
Now what it says? It amends which rule?
It is in 2, my lord. I am reading out. 3rd paragraph. Page 103, kind of a glance. 103 for a moment.
Correct.
Yes.
103.
Yes. These rules may be called as Odisha Pharmacy Service.
So,
Yes.
maybe. They go to
They
next.
shall come at the next. Then the
We understood.
point number 2. In Odisha Pharmacy Service Method of Recruitment Conditions of Rule 2019, hereinafter referred as the said rule, in Rule 4 for Sub-Rule 1, excluding the provisos, the following sub-rule shall be substituted, namely. So for the provide.
One second. Go to sub-rule 1 of rule 4 originally.
Exactly. It is at page 44 in the writ, my lord.
On the date of commencement of these rules, all the contractual policies we have been designated by concerned societies deemed to be and have completed 6 years of satisfactory contract system shall be deemed for regular government employees as one-time result. So all the fulfillment of eligibility as prescribed in Rule 5. Proviso is not necessary. Only sub-rule 1 alone is substituted.
Yes.
Let us go to 103.
Yes. On the date of commencement of this rule,
all the contractual we have been duly recruited by the concerned societies or schemes.
Yes. Or working in different fixed healthcare facilities.
Healthcare facilities only.
Only.
It is not only a category of people by this amendment.
Fixed healthcare facilities only. That means it has been confined.
What is the extra added by this amendment now?
This has been segregated because they are in all the contractual pharmacists. The language was all the contractual pharmacists. Here, my lord, all the contractual pharmacists who have been duly recruited.
Different fixed healthcare facilities.
Exactly. This has been added. I can say it is in substituted. The language it has been substituted.
That is removed and this takes its place.
By then, they have already been deemed.
Yes. March. It is in March 2019. This newly amended rule come into November 2020. By the time the Amit Mishra judgment of the Hon'Ble Apex Court, it has been pronounced. That has not been there. And apart from that, so far the writ application of this Hon'Ble Court, this has been disposed of in the month of February 2020. But newly amended rule comes in November 2020.
So
that is my humble assumption.
Pre-amendment.
Exactly. Indeed, it has not been taken care of.
If this amendment is kept in view, they have to be out of the court. Is it?
Because they are in.
No, I'm asking. We want to know the consequences. See, amendment. See, any amendment we have to interpret. We are not interpreting the statute.
Consequences.
We are interpreting the rules. Subordinate legislation. Is it not? Our interpretation varies depending upon the consequences of implementation. Suppose if the consequences are very, very implication-wise, very enormous.
It is coming to my mind, my lord. So far, I am demonstrating one example. Prior to that, there is no 108 scheme so far the ambulance is concerned. Prior to that, it was not there. Government ambulance was there. But frequently, the 108 has been introduced in our state. So there in many of the pharmacists also being employed, but it is a scheme. So this has been categorically stated. Concerned society oblique schemes have to be completed 6 years. In that way, it can be interpreted, Miller. But therein it has been said, concerned society schemes for working in different fixed healthcare facilities. Even it is CSC, PSC, all other things, it is fixed healthcare facilities. But this cannot be treated as a MHU, man.
Is there any report or discussion as to why this amendment was necessitated?
That time.
Any expert committee report? Generally, this amendment on the basis of the...
What is the requirement of this newly amendment even 1 year after? It is 1 year after. It is in the month of February and it is in the month of November, Millard, the next week.
But that was not pressed into service in the Supreme Court judgment.
No.
Why?
No, Millard. Because by that time it was not came up. Because the Amit Mishra judgment, it was come in 12/1/2021.
This came in November 2021.
It was in the November, but this was not discussed. Neither it has been discussed, nor it was ever reflected in the writ application before this Hon'Ble Court, because by that time it was premature. It prior to that.
How learned single judge treated this aspect?
Exactly.
Para 45.
This has been taken up para 47 for a moment, Miller. It is at page, I'm reading, 100 Miller. Page 100. As has already been observed, this writ petition filed prior to the amendment, as I have been
That's wrong.
That was wrong, Miller.
In respect of few, it is wrong.
Few.
In respect of all right. You are the writ petitions, which are the writ petitions they were filed prior to amendment? Give us. At least those cases will fit into this one.
Yes, fine. There are around 70-80 matters, Miller.
We do not know. Wherever you have to tell now, he will not be able to tell. Which are the
because individual laws are there.
Writ petitions?
And post amendment.
Now,
Post amendment.
complete them. For other cases, we will post it for further hearing.
Segregated it.
Shall I, if your lordship will, the background of amendment, I can explain to your lordship.
No, may not be. We'll come to that one next. Now, learned single judge proceeded on the premise all cases are pre-amendment.
Yes.
If it were to be so, he would have been justified. But all cases are not pre-amendment. There are post-amendment cases also. Those cases we will hear separately.
Not
We are
all,
not deciding that.
but all these cases are, my lord, regulation, claiming regulation after continuing for more than 2 decades, 1 decade, and the Honorable Single Judge has held that when the right has accrued as per the existing rule, you cannot taken away by the after amending after 1 year. My lord, what they have done, my lord, rule was framed in 8/3/2019.
No, I have understood that argument we will keep separately. Now give us the cases where pre-amendment cases which you had filed. Which are those cases? Going by your version, your demeanor, I feel yours are post-amendment cases.
No,
Pre-amendment also.
yes.
How many are there? Give that one.
Yes.
So that for rest of
Certainly, Your Lordship, we will find out those things. But only
because
yes, sir.
to the extent the right that accrued under the pre-amendment legal position, that cannot be silenced by these amendment. They are that for them that that
19
will remain in that.
And also Amit Mishra.
Correct. Amit Mishra is structured on 1990 amendment.
Exactly.
We agree with that.
That will come.
For a moment.
No, you answer.
Yes, sir. Yes, we'll give it, sir. We'll give it.
Just give the list.
List, sir. We'll give the list.
Yes.
Sir, only question is, sir, if your also will look to the judgment of the Honorable Single Judge, right from paragraph 45 to 47, though that particular case, which was a lead case, it was filed prior to that, of course, there are some cases which have been filed subsequent to that.
Those cases we hear them.
Yes, madam.
Because long service is put.
Not that, madam. The only question for constitutional lordship, so far as these cases are concerned, whether 4.1, the original amendment of 2019, deeming provision.
Original rule.
Original.
Not
That means-
amended.
Original rule means 2019 rule.
Pre-amendment.
Pre-amended.
March
Pre-amended.
2019.
That specifically provide deeming provision.
Correct.
That the date when commencement of the rule came into force, they are deemed to have been just like a validation.
Those
Just like
who have
for one time.
completed 6 years.
Right, sir. Right, sir. All contractual appointees, irrespective of fixed or non-fixed, but after completion of 6 years, they will be deemed to have been.
Provided conditions are complied.
What the Honorable Single has said, so that those persons, after it is applying the deeming provision, is deemed to have been regularized, then by way of amendment, that right cannot be affected. That is a vested right. You can't take away that right by way of amendment.
No, we are also not on that. We are also not on that.
So,
Unless amendment is charged.
your lordship, no.
That has never been challenged.
Just your lordship is asking us question. That certainly your lordship segregate for the purpose of facilitating that other course of argument can be advanced in other cases also. That
Because long service they have put in.
yes. Right,
It's,
Tagore and other
they
lordship
cannot
dealt with many cases.
by seeing that amendment is one version.
This is Sir Sir, you will give the numbers so that you will not segregate.
So far as the pre-amendment rule cases are concerned, they are covered by the.
Even accepting the amendment, if you also want to come that those judgment applies, ratio of those judgment, then working for more than 10 years, 15 years, 20 years, can they be discriminated? One. Second is, as you also rightly pointed out to Mr. Mohanty, that if you have done it in case of these mobile health units, so far as the other 4 districts are concerned, how can you make a discrimination so far as these cases are concerned?
No, that can be a ground for setting aside the amendments. But as long as Mr. Mohanty says, as long as nobody has challenged,
Nobody has challenged.
it has to go by the rules.
This is the version of the Honorable.
One aspect is to go by the rules, amendment or that deeming provision. The other one is continuous service for more than 10 years or 20 years, as you also have decided in many cases. That is also another part. You also will deal with that. That is another part. So if since you also are directors, we can also give the numbers which have been 5 years.
The subject matter of these petitions is substantially similar to the one treated by this court, treated by Apex Court.
No,
Yes,
Treated by our bench only. No.
This Honorable Court.
treated by the coordinate bench of this court in writ appeal number 1323 of 2023 between State of Odisha versus Chabindra Kumar Samal, disposed of on 2/7/2025.
In reference to
In the light of Amit Kumar Mishra,
State of Odisha versus Amit.
Amit Kumar Mishra versus State of Odisha. Correct?
No, my lord, it is State of Odisha versus Amit.
State of Odisha versus Amit Kumar Mishra. Number?
This is number is SLP number.
SLP
13077. I have given the copies.
Disposed of, decided by the apex court.
Yes, ma'am.
Why not? 12/1/2021.
Yes.
First up. There is no much dispute on this position. First up. In the above circumstances, these appeals fail, coupled with a direction to implement impugned order of the learned single judge, orders of the learned single judge within an outer limit of 3 months. Outer limit of 3 months. And without giving any scope for content proceedings. Okay. Give those numbers. The rest of the matters will have
Let a copy be given to me. By that, it will be easier for me to segregate it.
Yeah, they will tell now.
Yes.
Whoever it tell, it will be covered. Otherwise, we leave them as it is.
The WPC number 290.
By a memo, because series of matters are there.
Write and give.
Within launch, we are giving.
Typing a copy.
We can give it.
So that rest of the matters will hear that matter.
Next week, can we do?
Next week we do not, and we are not sure. Next week, we will go there. Week after next week.
My lord, in the today's weekly list, there's 3 items similar to.
Them to
I have
call up with.
Once you give the list, we can mark it.
We'll call them also. Okay. We'll have it on.
We commencing.
19th of.
We commencing 23rd, madam.
Commencing 23rd.
Okay.
23rd.
20.
February.
23rd.
Yes.
Okay.
As I've understood that all the matters which are filed prior to that, you will dismiss this one.
Disposed. So therefore, you have to give the list of cases.
Yes.
Otherwise, they also remain intact.
Yes.
Right.
Writ appeal referred against the single judge order.
Recording in progress.
The writ appeal filed against the order of judgment of single judge annexed 2. Order dated 8th January 2025. And WPC number 18,129 of 2016.
Yes.
The fact may kindly be permitted. This petitioner presently is 72 years old and has been pursuing 72. Now 72 years old, completely bedridden due to paralysis in 6 years. Still he is pursuing the litigation since 2010 till today. In several rounds of the litigations, number one.
Yeah. What is the substance of the grievance?
Grievance is irregular. Bank had charge sheeted.
Can you put on your mic?
Yes.
Yeah.
Bank has charge sheeted on the ground of irregularities in the sanctioning agricultural loans only.
What is the extent of loan amount?
Loans is all agricultural loans. So
We are asking a question to you.
Yes.
Because it is relevant. Supreme Court said in Sundaram Mani, wherever cases relating to over lending, etc. issues arise, court should ascertain what is the amount lent in excess of the ceiling limit.
No.
And whether that recovery is done
My lord,
is another thing.
My lord, there is no sanction cascade limit or over that exceeding lending power. Very clear.
What is the designation?
Designation was branch manager had posted at Fauzdari branch Patna.
For branch managers, there is a ceiling limit.
Yes, that is lending power.
Then that's what.
That question does not arise because he has never sanctioned any cascade or temporary overdraft in any manner. Only sanction was government sponsored scheme loans by block, by government industries such as KBIC, DIC like that. And all agricultural loans.
Tribunal says the integrity issue. Tribunal says there is integrity issue.
No, there is no such a matter of intention because basically this charge sheet was issued basing upon the bank's internal inspection department. They inspected the department and submitted dated inspection dated 5th February 2007. And the officer, he was in Odisha, completely phased manner, he got promotion to scale 2. As per bank's extant guidelines, he was posted at Fauzdari branch as branch manager. There he was to work for 3 years. Just before the end of 3 years, he was suspended, charge sheeted, proceedings, he was dismissed.
The IO held all charges proved.
Yes, all charges proved. Not all charges.
How many charges were framed?
That is out of 15 charges. 15 charges.
15.
15, 1, 5. 15
charges are all related to each other.
No, not different.
They are different, but not under what he had done. He had sanctioned loans and crossed the limits given to him, for which there were certain reports were there which were against him. So holding upon that, what had happened? Initially, the single judge, in the first round of litigation, told that you go for a re-enquiry because under a particular regulation of the Ecobank regulations which guide these enquiries, if the single judge held it has not been properly followed, you hold a re-enquiry. That annexed, he has annexed, if you lordship will page 38, para 16, relying on 2 things, my lord. That re-enquiry should be done relying on that regulation. That regulation he has also given a copy. That copy is also with me. Regulation 6 sub rule 30.
De novo inquiry. De novo inquiry.
Yes, no, that is my lord.
In fact, a re-enquiry was held, my lord, because he was given full opportunity, my lord. Though the inquiry proceedings have been annexed in the counter affidavit filed before the Honorable Single Judge. And in many of the charges, it was held that he had exceeded his power in giving loans and they had become NPA, non-recoverable.
Non-recoverable.
Yes, that is all there. If your statement of allegations are there.
That is not correct. He has not exceeded his power.
Let us see the report of the inquiry office. Because the inquiry officer's report.
My lord, the statement of allegations is there. If your lordship wants, I can read it. There are 15 allegations.
Report.
Because there,
what he said.
At page 134 of the
out of 15 charges, what are the nature of charges? What is the nature of
that is why I was trying to read out.
All are agricultural loans.
See, your 13 is only important. See, Mahapatra had financed more than 7.6 crores into different schemes without observing bank norms in such a way as if he has thrown away bank's money and he did not bother to take necessary steps to recover the bank's fund. As a result, the accounts turned empty.
My lord, this is the allegation. But in fact, when the inquiry was there, he placed evidences.
What the inquiry officer had?
My lord, findings of inquiry officer that
On
page.
this, the 7 crore odd which my brother has now pointed out.
Yes, yes.
Multiple.
How inquiry officer has treated the subject?
My lord, the
Let us see.
findings of inquiry officer is at page 134 actually of the writ application
134.
of the counter affidavit. A counter affidavit filed in the before the single judge.
Findings of inquiry officer.
That is the findings of the inquiry officer.
That's the report.
Signature E, my lord, findings.
Is it not the report?
Findings,
Yes, that is the report.
that is the report, my lord. He has given it, named it as a finding, but it is the.
All right, that is called like.
Yeah.
That is only findings is the report.
Report dated? It is dated what?
My lord, I'm saying. It is dated, my lord, 21/11/2015.
May not be. May not be. You are referring to the date mentioned in the first page.
My lord,
Correct.
I was not the conducting advocate. Whatever records have been given, I'm sorry for
Why are you
that.
speaking?
I'm sorry for that, my lord,
We are
because I'm
asking a
just,
question. You are going.
I'm just,
on,
there is a,
No, my lord, in order to.
report dated.
my lord, the inquiry officer has dated it 21/11/2015.
That is second round. First round is more important. First round litigation, Annexure 1, single judge has dismissed the quash the order of punishment directed for de novo inquiry.
Therefore, de novo inquiry.
Yes, and de novo observations made by single judge in the Annexure 1, that is more important and relevant. I may be.
Let us first we'll see what is the report. Then you can show the
There are two
findings
reports.
What is it?
Are there.
What was the first report, then second report? What is the first report?
in the de novo inquiry. Only one report.
Yes, one.
That's all report.
That report we have to see. How we are approaching in the disciplinary matters. In disciplinary matters, the first principle is court is not the appellate authority.
My lord.
So this is a intra-court appeal.
Yes.
Therefore, there is some restriction even otherwise. Number 3, whether findings of the inquiry report are perverse
Yes.
or they are without evidence. That we have
These
to
two
assess.
things are there. I'm sorry, I'm going to
Let us
substitute.
we'll go by step by step. There is a methodic approach in service law.
Yes. First of all, the inquiry was held deviating the bank's own rules.
Let us-
Guidelines.
let us-
Finding charges are out of 15 charge allegations. I think.
Come to the findings.
11.
Come to the findings. Then take us through the findings and show us each of the findings is unworthy of consideration.
Yes.
Then we'll go to the authorities finding how it has viewed the report of the inquiry. There also, there may arguably appear any defect. Inquiry report is 21/11/2015. How many charges? We will help you now.
Yes,
To
yes.
conduct disciplinary matter.
Yes, yes.
How many charges?
51 to 53.
How many charges?
My lord,
There are
15.
1 second. Out of 15 charges, how many are held to be proved?
My lord, other than charge 2, 7 and 15, all others have been held to be proved.
No, not proved. Some are not proved, some are proved.
That is what he is saying.
Except 2,
2, 7 and 15.
And 13, last.
No, what is there? I'm reading from the
15. So 12 charges are proved now. Which is the gravest of the 12 charges? Which charge is grave?
Nothing.
No, my lord.
No.
He has crossed his limit when he was
These
at
charges are crossing the lending limit.
lending limit and they have become NPA, non-recoverable. So, my lord, I have got a decision of the Apex Court where these sort of things.
Further, we are asking.
Yes, my lord.
Step by step.
Yes,
we are-
my lord.
First point
Yes.
is
By exceeding his lending power
That's-
and not the land documents had not been properly filled up. He had given loans beyond his area of jurisdiction,
3 things.
my lord. And one inspection report.
What
Which
has
is
happened to
listed
you?
then?
What has happened to you? Have you had your lunch? You had? You did not? Then we'll have this matter some other day after eating the lunch, you come here. We are his helping.
Sorry, my lord.
Say, out of 15 charges, 12 charges are proved, according to the IO.
My lord.
Alright? The gist of all these charges is overlending.
My lord had financed in gross misuse of his power without taking application forms, without process note, no valuation certificate taken, pre and post sanction verification follow-up were not done, income certificate not taken, non-encumbrance certificate not taken,
Very well,
mortgage
brother.
of land.
Go one by one.
So these are
Overlending. Please listen to us. We had very humbly, I say we had
No, my lord, I am sorry, my lord.
lot of experience in service matters. Therefore, kindly listen to me. That may help you.
My lord.
That may help you also.
No, my lord, let me explain the position. There is no overlending.
Wait and listen, then you will.
Understand that.
Unless we understand, how
banking
can we?
matter.
Yes.
It's a banking matter. There is a pattern for that. Number one, there may be overlending. There may not be overlending. There are allegations of overlending. Correct?
No.
I agree with that. No overlending.
No.
You read it, na?
I'm reading the
No, that is,
I can read the
findings, not the allegation. Findings are different, allegations are different. Allegations are not based on the.
All right, read the first allegation. Read first charge.
Master.
One by one we'll go. Let all people wait. What to do? We are
This is charge sheet. Dated.
Brother, can we suggest something to you,
My lord,
to both of you? These are disciplinary matters.
my lord.
In disciplinary matters, approach of the apex court is called out by Justice Ramajais and by VD Kulashrestha.
Yes.
How in banking matters court should approach. A pattern is worked out. Only thing is you have to turn the pages of those best books. Then you will be able to argue.
Right.
Otherwise, haphazard argument you will do, haphazard judgment will hand, justice will not be done to anybody. Therefore, I am telling you, kindly listen to us. First one, what are the charges? 1, 2, 3, 4, A, B, C, D.
Yes.
How many charges are held to be proved? Second column. What is the evidentiary material in support of this, each of the charges proves? According to you, which evidence is incorrect, because legally impermissible,
Yes.
or it is highly insufficient?
I understood. And now I am systematically submitting.
Come with a pattern.
Yes.
Not like this.
This charge sheet was issued.
No, brother, we will not hear you. We will not hear you that way.
Allegation.
Pattern we need.
Yes.
Bring a chart.
I'm telling. This is
Not
our.
telling, bring a chart. Which witness said against you?
Statement of allegations are there. I may be.
On this matter after 2 weeks to enable advocates to come with more preparation and with a chart. Yes, next.
Number of allegations wise.
We have told you now.
Okay.
If you want to understand, understand. Otherwise, we are not teachers here.
My lord,
Judges here.
may I pray, my lord? After 2 weeks let it be. I am agreeable. That would be specific date.
All right, take whichever date you want. But you have to prepare this way. Kindly listen to us. Next date, if you do like the same thing,
No.
we'll dismiss the case.
Right.
You have to prepare a chart.
Yes,
There is a
yes.
method for argument.
Yes.
Not traditional lawyer's argument.
The way you are advising, I will do it.
First, prepare a chart.
Yes,
Okay? Wasting time of the court. Yes.
Any day in February.
All right, we have heard you coming without item tag, no methodology, no pattern. Coming and arguing as if some appeal is being argued.
May I be 25th?
All right, 25th, call on 25th.
25th February.
Yes, next. Item 10, kindly prepare well, otherwise you will not be able to do this.
No, I'll
You will disturb our sleep.
I have understood what your lordship wants.
Prepare
I
one
understood.
chart.
The manner
Simple
your
chart.
lordship wanted a stepwise.
Stepwise, it's a pattern. It's a pattern. Just turn the pages of Ramanujan's question. You will know how in disciplinary matters, more particularly banking law, you have to prepare. Only you have to prepare the chart. A, B, C, D. What is the evidentiary material? Where the IO has erred. These are the type. Where is arguing that? Yes. Item 10. Next. Yes, my friend.
Lord, the appellant, the public sector undertaking, what's the state
Article 12 entity.
industrial corporation, my lord?
So Article 12 entity.
Yes, my lord.
Yes.
But appellant, my lord, on challenging the order of the Honorable Single Judge, lordship kindly see that is page
60.
that is page 61, paragraph 8 is the finding of the
Drugs of the matter. We got this.
Page 63, the relevant page.
Seek the concurrence of the board.
Yes.
For regularization of
Yes,
services
yes,
of
yes,
Dixit Krishna.
Yes.
Instead of taking a plea of any such approval of the government, the same is going to be not necessary. In other words, court is inclined to direct the petitioner to ensure such regulation in compliance of the direction issued by the three seeking concurrence from the director and to go for such. What is that?
Paragraph 8, in fact.
Annexure 3. Take us to Annexure 3.
Annexure 3. Annexure 3 is that is
earlier order.
That is page 55. Can you say Annexure 4? Annexure 4 is the speaking order. Lordship said in paragraph 8 that Annexure 4 is the speaking of what happened in the case. Earlier he filed a writ. In the writ application, Honorable Single Judge said that you take a decision as per law. So we have taken a decision and issued a speaking order. The speaking order was challenged in this present writ and so arising out of this writ appeal. In Lordship kindly see the speaking order is page 55, running page 55. In Lordship will gather entire knowledge 55. Page 55 the brief.
Since 1993, November, he has been working.
93, initially in 93, subsequently some disengaged, subsequently filed writ application, then subsequently, in fact, engaged, then subsequently disengaged, then he filed another writ, then disengaged. So since 2014, he is continuing as a data entry operator. He is continuing data entry operator. What happened? Our plea is, my lord, that in fact there is no post. In view of that Uma Devi's case, in fact, has not engaged in procedural manner, and that is why I said that we can't regularize him against that post.
You said there is no post at all.
There is no post at all. We said that there is no post at all.
But you have been continuing all these years.
My lord?
All these years with the breaks.
No, that's correct.
You have been continuing.
Since it's continuing. Initially, is a contract matter in the contractual engagement was made. Then subsequently for operating the computer was engaged. Then in 2014, he was engaged as a data entry operator. But then as per the pattern data entry operator, he said that data entry operator post was not there. So that is why my plea was that in fact, Lordship candidate is a very small speaking order. I think let's see if the entire speaking order, entire case will be
page number
55, I said. Running page 55. Lordship got that?
Yes.
Yes. May I read? You'll permit to read, so that is only. Yes.
You also read, we will also read.
I'm reading the third paragraph. And whereas the petitioner has submitted a representation to 2024, disclosed in the copy of the Honorable High Court's order.
What is DO?
Data entry operator. Data entry operator, my lord. Then, and whereas the petitioner has been offered a temporary appointment in Orissa small scale unit corporation as DEO on contractual basis as per the appointment letter such and such as 93. And the petitioner joined in DEO 93. And whereas the petitioner was disengaged from the temporary service of OSIC on 2003, with effect from 2003, and after the assessment by a committee, if I order number such and such, then let's go to the next page. Sorry, my lord. And whereas the petitioner had filed a case in the writ application of such and such, seeking a direction for engagement as computer operator
and the said case was disposed of on 28/3/2011 with the direction that if the work is available for the petitioner, then the corporation may not utilize the service of the employee working in other corporations and may comply with the decision of the Board of Directors on 7/1/2004 by engaging the petitioner, if not on regular basis, but on contractual basis then. And whereas the petitioner was engaged in data entry operator, that's in 2014, on contractual basis for a period of 1 year, temporarily, without being entitled for any benefit or privilege by the order number such and such, such and such. Now, whereas on completion of his contract period in 28/2/2013, his service was not extended. Then he filed another writ application, and the petition moved to the High Court such and such writ application. Then, and whereas the communication of the order passed by the High Court as dispatched by the Superintendent of such and such High Court 14/8/2014, in his due obedience, the petition was re-engaged as DO, that is on a contract basis, with effect from 3/12/2014. He is continuing from 3,000 continuously performing duties, no adverse, nothing. So in this, and whereas the petitioner approached the Hon'Ble Court for regulation of service with small scale corporation on account of his experience and limited service tenure available. Then last paragraph is relevant.
That I have read twice.
So now therefore the verification of records, it was found that the petitioner has not been selected for it, etc. So my humble submission is that since our ground is, my lord, that in fact there is no post, even if he is continuing by virtue of this Hon'Ble Court's direction, he is continuing since 2014. So my opinion is something else, my lord. So that is out of the court. My opinion is that since a considerable length of service they are working, so that is also that is out of the court.
Whatever we wanted to say, now we will make it inside the court.
So since it's
2093 he has been, since 93 November.
That's correct.
Since 93 November. He has shed his blood.
No. 93 and subsequent, that is computer work, functioning as a computer assistant. That's
how you took his services is not important. But you have taken the services initially for 10 years.
I agree 101% your lordship.
Then the matter has to be dismissed.
Sir, only one ground. Then this aspect already I said that yes, my view is something, but only one ground you will actually appreciate, because of this is an industry department. In another case also, that in the industry department, what happened, that moved because of data entry operator, Honorable Division Bench said that you create a post and engage them. So in oil and natural case corporation matter, they had been to Supreme Court.
ONGC. Which year matter?
This not particular, another state.
Which year?
That is a 2022. Lordship can see this. And also state engaged Solicitor General.
Whomsoever it may engage.
That may. Lordship can see this order. That is the only problem. Otherwise, regulation.
Even beyond ONGC, because the other judgment refers to ONGC.
Yes.
And then this ONGC we diluted.
That's correct. In that judgment, the matter is still pending.
No, one matter is disposed of already relating to the ONGC.
Let's see that. If disposed
where they say there is no post and therefore we cannot regularize, Supreme Court did not agree. The fact that for 93 to 2023.
93, my lord, I am with regard to 93, my lord, 93 to 2014. 2014. Because in 2014 he was engaged as a data entry operator. Prior to that, my lord, 5 to 6 years, 10 years gaps are there.
Because that gap, the court did not agree.
That's correct. So I said that the outside I said, lordship, 2014 is also continuing. There is no adverse, nothing. So my lord, lordship can see that judgment.
This is a wrong on the part of whom?
Part of whom there is no wrong, because the matter is because lordship's matter is pending, because the writ appeal is there, and that is why we waited. Otherwise, my lord, that would have been disposal. Matter is also with the government and also with the board. The board will decide the matter. Board will
Let
decide.
us see what Jhansi Rani will say.
No, that must bomb, but see, my sister is always, he said that whatever you say, my senior, what happened, out of 2 persons have already been retired. They will get some money. And 2 persons are still continuing, and also within 1 year also they will retire. As your last please.
Wait 1 second. Our constitution is amended.
That's correct.
And they have added the word socialist along with secular. Earlier, those 2 words were not there in the preamble. What is meant by socialism?
After
the words in the constitution are meant for something. Whether I agree or you agree, that's not the point. We have taken the oath to do justice according to law. Whether I like or not. Left to myself, I may not agree. But as Justice Dixit, Justice Das, they have no option. We have to infuse life into that world. How we will do that?
And also after that, where they'll go. In this age also, where they'll go. 2 persons.
Where they should go. Who will entertain them?
That is also a word in my mind. That's why I said. So in this juncture, Lordship kindly see that this is the situation, this is our grant. And also there's, when this is judgment, Lordship can see. That's an order, that's a pending. Lordship can see, just have a glance.
Pending, whatever happens to that, you can take, in the meanwhile, if it is decided in your favor, then you can take the matter to the apex court also. Or you can tell the apex court similar matter is admitted. Admit this judgment also.
Admit collection, labor or disposal.
That's what we are disposing of. Anything you want to say? To loosen the views of other side.
Yes, my lord. My lord, only one point that before that there was a judgment. They were never challenged that judgment.
What it says?
Para 51 of page 15, my lord. All the MD on the careful analysis of the letter written by the managing director of corporation to government, this court found that the managing director of the corporation has recommended the case of the petitioner for regulation of his service, supported by sound and strong reason. One of the major reasons on which the managing director of the corporation has recommended the service of the petitioner is that petitioner has been working in corporation for a long time and that corporation has utilized his service on regular basis, keeping in view the perennial nature of workload of the corporation. In both the letters, dated so and so, as well as 27/2021, the managing director has recommended the case of the petitioner and similarly situated other employees for regularization for their services. Letter dated 28/7/2021 attached to the interlocutory application under Annex 19 reveals that in the event of service of the petitioner is regularized against the post of junior assistant, no additional financial burden would be imposed on the corporation. So, my lord, this is the recommendation of MD. Now, new MD has come.
So my
Court appeal
may I submit one thing?
Seeks to lay a challenge. We have heard you. We cannot endlessly go on hearing in small matters. We have allotted some rationing of the things as to done. Otherwise, you will go on arguing.
No.
The rest of the people have to
No.
sit as mute spectators. That we are against. This is a writ court. It has to ration its time. Yesterday, we have spent 2 hours in one matter, which should have been completed within 20 minutes. Kindly be seated, sir. We will not hear that. We are a writ court, intra-court appeal. Yes. What are your returns? This intra-court appeal seeks to lay a challenge to the learned single judge's order dated so, whereby OP's WPC number, respondent's WPC number 9309 of 2024, having been waived, the following relief has been granted. You reproduce that relief. Next paragraph. Learned judge appearing for the appellant vehemently argues that the imbue judgment runs counter to the jurisprudence of Umadevi jurisprudence. Semicolon. More or less in a similar matter, between SLP number 24226 of 2022, between Vice Chairman and another versus Manoj Patra and others, the apex court is examining as to the legality of directing regularization in the absence of permanent sanctioned post. and therefore matter requires deeper examination. First off, he also draws our attention to the break in service, which eventually had driven the respondent to the court more than once earlier. First time. So contending, so arguing, he seeks allowing of the petition by widening the impugned order of the learned single judge. First, learned counsel appearing for the, kindly be seated, appearing for the respondent employee opposes the appeal, drawing attention of the court to the reasoning of the learned single judge, more particularly at paragraphs 15 and 16.
15, my lord.
15 and 16. Next two. Which in turn refer to the recommendation of the managing director of the appellant company, chief public sector entity. First off, she also presses into service the decision of Apex Court in Jago, Shripad, and
And Bhola. What?
And Bhola.
Bhola, not sir, what is that? Bhola. Yes, give these all four judgments, give citation of. Right down. She says that the single judge has perfectly reasoned the decision, and therefore interference of this court is uncalled for. Next, having heard learned counsel for the parties and having perused the appeal papers, we decline indulgence on the matter, broadly agreeing with the reasoning of the learned single judge. First off, it is relevant to reproduce what he has observed at paragraph 15 and 16 of the impugned order. Reproduce that. Next paragraph. There is force in the submission of learned counsel appearing for the respondent that the law relating to regularization has marched from Dharwad daily wages so and so to Umadevi and to Bhola at the latest. First, to a great extent, the interpretation placed by the learned counsel appearing for the appellant on Umadevi appears to be unworthy of Dixit, appears to be unacceptable, is unacceptable, acceptable because of the march of law. First, next paragraph. The contention of the learned counsel for the appellant that identical matter is being debated, question is being debated on the floor of the Apex Court in Manoj Patra Supra is no ground for undertaking a deeper examination of the matter. First off, merely because a question is being debated on the floor of highest arbitral tribunal of the country, there is no law which says that all courts should await the final decision on that. First off, it is relevant to observe that wherever the Apex Court desires that because of pendency of a particular matter, the other courts and tribunals should keep off their hands from expressing their views, does not find any support. First, the Apex Court in the case of which is that judgment where 2013 Land Acquisition Rehabilitation Act was said, Supreme Court said, don't touch paper matters relating to this section 24 of 2013 Act. Baroda Development Authority. Let's take out that. The Apex Court in Pune Development Authority versus so and so, while examining the legality of section 24 of Right to Rehabilitation, etc. Act 2013, had directed all the courts in the country not to examine the questions that were being debated before it. First off, such an injunction we do not find in the decision cited in Manoj Patra. First off, in the above circumstances, appeal being unworthy of merit is liable to be rejected, and accordingly it is rejected at the preliminary hearing stage. First off, the appellants are directed to implement the impugned order of the learned single judge within an outer limit of 8 weeks, without driving the poor respondent employee to one more legal battle. Yes.
Item 11.
We have a small request to the bar. First one is intra-court appeal. Second one is it arises from writ jurisdiction. Writ jurisdiction makes our court of equity. Therefore, no very long and we have to show by short argument what is the error in the judgment. Because it is more like 227 now. It does not travel to 226 also. Had he been here, it would have traveled to 226 because it touches his right to livelihood. For a corporation like yours, where is that question?
The outside has said.
No, I do appreciate you.
That no error has been committed.
I have respect for you. But could
give him some time.
We have given 8 weeks.
Co-placement.
Yeah. But subject to condition, you should not drive him again. Yes. Yeah. Otherwise, we have to decide only regulation matter. High Court becomes an ordinary time.
But it to be implemented.
Yeah.
Item 11.
Cost may less than yes.
The petitioner challenges the order by the
ground we have to. Sir, 1 minute. That one I am adding one more. Yes, sir.
Mr. Das.
1 minute. We want to add one thing. We need to observe that in the 42nd Amendment, the word socialist has been introduced to the preamble of the Constitution of India. First off, it is not without any significance. First off, the principles of socialism are beneficial to the working classes. And therefore, that aspect has to be borne in mind by all constitutional institutions while dealing with questions raised. Questions of the kind raised. First, this one.
Well, I appeared for my lord's respondent 5.
What is the significance of socialism?
My lord, I appeared for respondent 5.
Yeah,
my appearance.
Not
Item 11.
Can anybody tell us what is the significance of the word socialism, socialist, appearing in the Constitution? Any judgment?
It is to give more meaning to the welfare state concept. That the welfare state means it's an equity and the equitable distribution of state largesses, that concept, that equal opportunity that is there. But these state largesses and the equity should be to the bottom, to the last man, it should reach. That's the more broader concept that your lordship has rightly appreciated, rightly reiterated in many judgments that we are grateful to your lordship for giving.
Anyway, just if there is any material,
that your lordship,
any write-up, just give.
Yes, and that write-up I will collect. I will definitely collect. But your lordship said that to infuse life to the word.
That's one. Yes.
The order dated 14/2/2025 passed by the Loan and Debt Recovery Appellate Tribunal, Kolkata, in appeal number 70C of 24 is under challenge, my lord. So, Lord, here, my lord, I am the auction purchaser. The petitioner is the auction purchaser. After being successful in the auction, I was issued with a sale certificate by the bank.
Yeah.
And my lord, that was challenged before the London DRT Kotak.
Who challenged it?
The borrower challenged it.
Opposite party number 1. He has not appeared so far, my lord.
We will not wait for him.
There is a noting is there.
It is served.
Notice is served.
Track report.
The track consignment flag so that it is served.
It is served. Call out name of the party. OP1. Respondent 1, OP1.
OP1.
Sandeep Jaiswal. Sandeep Jaiswal.
There, my lord, the section 17 application filed by the borrower was delayed. So
What?
that it was filed in delay.
Huh.
Therefore, interim application number 827 of 2019 was filed along with the sufficient.
Seeking dismissal of that essay.
Seeking condonation of delay of that.
How many days delay?
Admittedly, there was 1 year, 2 month delay they have admitted in their application.
But the condonation of delay is limited.
Well,
under section 17.
It is not available to the tribunal or because there is no provision under the act to
condone beyond limit.
And subsequently, that interim application was not pressed. Another interim application was filed, even there is no prayer for condonation of delay. Let's say grants to the prayer in the subsequent application, that prayer will appear to be a peculiar prayer so far as the condonation of delay is concerned. However, my lord, the Law and Debt Recovery Tribunal dismissed that application, and consequently, the essay was the surface application was also dismissed. The borrower carried an appeal to the appellate tribunal. The appellate tribunal had the impugned order.
Reversed it.
That is the impugned order here before reversed. And my lord and senior appearing for the bank, my lord.
I am appearing. I have sold the property and he is the purchaser.
In the purchaser. No, where is the? Because courts have taken the view. Whether section 17, which prescribes how many days of appeal limitation?
45 days, if the 45 days it has to be filed.
45
the
days.
measures taken.
And delay, condonation of delay limit is?
There is, my lord, no provision under the act.
No delay, no condemnation. They only 45 days.
Only within it.
End of the matter. Any ruling in your favor?
My lord, contradictory ruling, my lord. So our High Court has contradictory view on that part. In Bourbon Cooperative Bank, well, the division bench said that there is no scope for condonation of delay. But in other case, my lord, this division of the coordinating bench said that there is a power of that needs to be settled.
Then we'll refer the matter to the full bench. Show the judgments to refer. Also, we need some material, no? Judgment of apex court. That's what. Apex court say. Apex court say, unless there is a provision like section 5 of the Limitation Act 1963, there cannot be condonation of delay in appeal like this.
The appellate tribunal is relayed the Sandeep Jaiswal case of this Hon'Ble Court.
Where section 5 like thing is done, where they have power to condone delay.
Power to so that's not the case. It has been held that power it can be condoned. But
what is the ground shown for condonation? Power to condone is one thing.
Well,
exercise of power to condone is another. Now we'll say that there is. We'll assume that there is power to condone.
Is a power.
What are the ground subject?
Well, the grounds they have taken that there was pendency of the litigation after the application, after the e-auction sale notice was issued. There is a writ petition that was filed by the borrower. That writ petition was dismissed was disposed of after 1 year. Thereafter, he filed a miscellaneous application in a disposed of essay, which was filed by him prior to that sale notice. That MA was also disposed of with a dire liberty to approach in appropriate forum.
That was disposed of when?
My lord?
That MA was disposed on, miscellaneous was disposed of.
That miscellaneous application.
When the DRT made the order?
Well, the DRT made the order of rejecting this dismissal, rejecting the condonation of delay. That was in 29 to 2024.
29 to 2024.
Well,
the order which had challenged before the DRT, when that was made?
When the essay was filed, the surface application was filed.
Essay number?
Essay number. It
2519 of 2019. No.
It was not numbered essay because delay was not done. It was filed on 17/12/2000.
Essay diary number 2519.
My lord.
Essay diary
number. Indian number.
And a new diary number that is recorded.
This was against which order?
My lord, the essay was filed against the e-auction sale notice before the DRT. E-auction sale notice dated 24/8/2018. The essay was filed on 24/8/2018.
That was section of section 14, section 13.
13.
And 86, Rule 86, published under Rule 86.
Section
Public,
13, subsection
13.8, no. Which one is that?
the sale notice under Rule 8, 6 and 9.
Read which section, which?
9, 13.4. 13.4.
13.4. Read with Rule
8.6 of the Security Interest Enforcement Rules.
Essay was filed on?
Essay was filed on 17/12/2019.
Delay of how many days? Correct, arithmetically counted?
My lord, admittedly, Lord Civil glanced to.
No, we're asking you.
My lord, it was 1 year, 2 months. 1 year, 2 months, 13 days.
Totally how many days? It should be always, delay should be counted
My
in
lord,
days.
I am sorry. 16,
Because limitation is prescribed in days.
420, 418 days.
The bank supports his case or?
Yes, my lord, I
bank
support
supports
it.
his
I
case?
support.
My lord, this initial application for condemnation of delay was withdrawn. That was never pressed for hearing.
Subsequently, one more application was filed.
Subsequently, in 2023, one more application was filed. With a prayer.
Were withdrawn with liberty to file one more application?
No liberty.
That IA was filed when? Is it numbered? Is it numbered here?
Well, IA number 492 of 2023.
First IA?
No, first IA was 8/27 of 2019.
This was filed when and withdrawn when?
This was filed on 24/12/2019.
As on the date the appeal was filed?
Yes, and the data. Along with the appeal memo.
This was disposed of as not pressed.
Not pressed.
When?
That was by the order dated 29/2/2024. By the which order the other interim application was also rejected.
Which order dated?
Order dated 29/2/2024.
In the meanwhile, one more application was filed.
In the meanwhile, one.
Then it pales into insignificant. Other application was also here filed subsequently.
Yes,
that IA is?
That is 492 of 2023.
Filed under which section?
That was without mentioning any section, but application for appropriate order.
What is the prayer?
Condoning delay.
My lord, the prayer is
to condone delay.
Is not there.
Approximately, somebody reads the corridor of the court, if reads that, what is the prayer?
Assuming it is for condemnation of delay. But the prayer is, Lordship, is otherwise. May I read the prayer? In view of the submission made above, your petitioner prayed that this honorable tribunal would be graciously pleased to allow this petition, and on hearing the counsels for the petitioner, the delay caused in filing essay.
That's what, for condemnation of delay.
Well, by the
prayer could have been beautifully drafted by Wren and Martin. Is another thing. If somebody understands what is the prayer, because it's a tribunal, not court of law.
So, my lord, that was also
What is
rejected.
the amount involved?
My lord, I purchased it at 75 lakh 14,000.
75 lakh?
14,000 in 2018.
2018.
That is the sale consideration outstanding, my lord, and
That point of time, another 19 lakhs was outstanding. In 75, 19, it's a long run. My lord, the matter related 2017. And it's going.
Loan of which year?
Loan of, my lord. 7.
Which are the two decisions? Which are the two conflicting decisions?
That you are referring to right now.
that was Urban Cooperative Bank.
Yes.
Register Urban Cooperative Bank.
Give the citation, brother.
My lord.
Where there are two conflicting judgments, what is the position in your High Court?
Referring to the full bench.
Referring to the full bench. Which section?
Usually that is.
No, we have a rule, sir. We have a rule, High Court rule. Our judge.
Both judgment I have not followed. I'm sorry.
Whether they are referred to in the order of the DRIT?
No. In one judgment they have referred.
Which judgment they have referred to? Which is
Sudeshna Desh versus AGM State Bank of India, they have referred.
Which is that citation?
But the citation with the case number they have referred. The DRIT.
Not reported.
Not reported. But she may allow me some date I can get both the judgments.
We have already used sufficient. We will not again and again use that time. People who go to the war front, they should go with the weapons. And because the enemies will not wait. They will not give opportunity of hearing to you. You can't tell them, give an opportunity, we'll bring our weapons here.
I'm experienced, sir.
Take down. Auction amount is 75.14 lakh.
75 lakh 14,000.
That's why. And the loan amount is?
Loan amount is more than that, my lord. The exact amount will be around 90 lakhs.
About 90 lakh?
90 lakhs.
Is it the industrial loan, a business loan, housing loan?
Business loan, man.
So commercial rates of interest.
My lord, I beg pardon, my lord. Now it is more than 60 lakhs. After adjusting this amount.
No, it's not like that. It cannot be half. It can be also. No, it cannot be. This 90 lakh as on which date?
As on which date? 2018. And this after this auction was made, 2017-18 auction was there. Thereafter the balance money, what was there, and that was the order passed by this landed tribunal reflecting that this thing, and he is liable to pay that amount also.
Whatever gap we need while giving dictation, that you assist me. All right. That's all. Take it. A successful auction buyer of security property is invoking the writ jurisdiction of this court for assailing the order dated 14 14/2/2025 made by TRAT Cuttack or Bhubaneswar? Kolkata.
DRT.
DRAT is in Kolkata. DRAT Kolkata, whereby SA NDN number 2519 of 2019 filed by OP number 1 borrowers having been favored, application in IA number 492 of 23 seeking condonation of delay in filing said essay. It is called essay or what?
Yes, sir.
Said essay has been favored. First of all, resultantly, the pending essay needs to be heard on merits. First, learned counsel appearing for the petitioner submits that under the statutory policy enacted by the Parliament in Section 17 of Surface Act 2002, there is a specific period of limitation for filing the grievance before the DRT, namely, what is that number? DRT number?
DRT 17.
What is this? What it is called? Appeal number or what?
SA number.
SA number 70.
SA was very died number 2519 of 2019.
That is DRT. DRT?
DRT is Appeal 76
of 76 of 2000.
Appeal 76.
Appeal 76 of 2024. Above the mention. Where is what to read? Not here. Now read now. Grievance, that is second appeal it is. SA means
regular. It is regular.
SA means what?
SA is the securitization application.
So filing that is SA number.
SA was by the diary number 2519 of 19.
This diary. Filing the SA for filing the SA. So once the period of limitation expires, the right to challenge withers away. There is no provision like Section 5 of Limitation Act 1963, providing for condonation of delay. That being the position, the DRT was more than justified in handing the order dated 29 February 2024, whereby OP number 1's SA number NDN 2519 of 2019 filed on 17/12/2020 was rightly rejected, and as a consequence rejected, because the condonation of delay application was rejected. First time. Notice, next paragraph. After service of notice, the panel counsel of the bank has put in appearance. First off. However, the OP number one, who happens to be the borrower, has chosen to remain absent despite the postal track record showing the effective service. First off, the name of OP number one was called out loudly thrice by the courtmaster on our instruction. First off, there is no response. First off, that would not deter the court from deciding the cause at hand in accordance with law. Next paragraph. One more sentence, right? Learned panel counsel appearing for the lender bank makes a submission in justification of the order of the DRT and in variance with that of the impugned order. First, next one. Having heard learned counsel appearing for the parties and having perused the petition papers, we are inclined to grant indulgence in the matter as under and for the following reasons. 1. Your OP number 2.
2 and 3.
2 and 3. OP number 2 and 3 are the lending agencies. Semicolon. OP number 1 happens to be the borrower. Semicolon. It is submitted at the bar that the outstanding loan amount as on which date?
As on date, my lord.
As on this day, how much it will be?
It will be about 60 lakhs.
As on this day will be 60 lakh.
After adjusting
60 lakh.
Adjusting the,
that is after adjusting the auction proceeds of the security property. First off, the auction was notified, was scheduled by the e-auction. E-auction was scheduled by notice dated 24/8/2018 in terms of section 13(4) of Surface Act 2002, read with the rule 8(6) of
Security Interest and Personal Rules 2002.
Write down. Get that. Write down and give that. Rules, so and so. Rules. First off, the essay in NDN 2519 of 2019 was filed by the borrower, OP number 1, on 17/12/2019. Is the date correct? 19. First off, arithmetically, there was a long delay of 418 days in filing the same. First off, IA number 827 of 2019 was moved on the day the essay was filed, seeking condonation of delay. First off, during the pendency of this application, another application in IA number 492 of 2023 was moved for the same purpose. First off, matter was heard on 29/2/2000. Was it reserved and disposed of?
It was disposed of.
On the same day, the dictation was given. was heard, the matter was heard on 29, these IAs were heard on 29 February 2024. First up. IA number 827 of 2019 was dismissed as not pressed, whereas IA number 492 of 2023 was dismissed on merits. Correct?
Yes.
Merits. First up. Next paragraph. Learned counsel for the petitioner is right in telling us that the DRT was more than justified in dismissing the borrower's IA number 827 of 2019 and IA number 492 of 2023 on the premise that there was no condonation, no provision in section the 2002 Act enabling the tribunal to condone delay if grounds do exist therefore. First up, we are aware that power to condone delay is one thing and the grounds for exercise of that power is another. First up, our perusal of the records show that the grounds mentioned for condonation of delay were properly adjudged by the DRT and thereafter the same was, the application was rejected. First up, of course, the DRT also mentioned about the absence of power to condone delay when when essay is filed after the expiry of the limitation period, correct?
That finding was not by the DRT.
That sentence. I suspected it. That's it.
The bank raised that objection, but that could not be addressed to.
We are told at the bar that the bank had raised the objection as to tenability of the application for condonation of delay once the essay was filed after broking delay. First, ordinarily, the power to condone delay has to be granted by the lawmaker. By making a provision, therefore, or by adopting the provisions of Section 5 of the Limitation Act 1963. First of all, obviously, such a provision is obviously not such a provision is conspicuously absent in the 2002 Act in general and Section 17 thereof in particular. First off, next paragraph. As already mentioned, the DRT could not have condoned the delay by allowing the application of the borrower even on the merits of the very said application itself, assuming that there was absolutely no power to condone delay. There was power to condone delay. where the parliament has enacted a particular policy that no challenge is permissible beyond the period of limitation, courts cannot rule to the contrary. First off, an argument to the opposite would cause breach of the doctrine of separation of powers, which is held to be one of the basic features of the Constitution of India in Indira Nehru Gandhi versus Raj Narayan. Just look into the citation. Can anybody give the citation? Yes. 75, Supreme Court. 77, 76. Next paragraph. The possession is given to him. Possession is not given. The auction of the security property was held. It was held on what date?
It was held on 7/9/2018.
7/9/2018. And the petitioner, being the highest bidder, has remitted, how much money have remitted?
75,14,000.
Entire auction amount, that is rupees 75.14 lakh. When did you pay that?
5/11/2018.
On 5/11/2018.
Accordingly, sale certificate has been issued.
5/7 or 7/9/18 was the auction.
5/11, after receiving entire dues, we have received issue sale certificate. 5/11/2018.
OP, the lending agency, not lending agency, OP number 3 has granted the certificate.
I have given the certificate.
OP number 3 has already issued the sale certificate. Is it registered in your state?
It is now these matter, not registered.
Not registered?
No.
It needs to be registered in
It
your
needs to
state.
be registered. It has to be entered in the book 1.
Book 1 alone. So, no stamp duty.
No stamp duty.
Little correction, my lord, is OP number 2 issued the.
OP number 2. OP number 2 issued the sale certificate. First off. Therefore, the auction buyer has to be put in possession of the property on a war footing. First off. Otherwise, in public auctions of the kind, no scrupulous person would come forward to participate in the public auction, and that would arguably result into the auction fetching lesser price for the security properties of the kind. First of all, this will cause enormous heartburn to the borrowers, whose interest also needs to be protected. First of all, in the above circumstances, we make the following order. 1. We issue as number one. Issue a writ of certiorari quashing the impugned order dated, what is the date of the DRAT?
14/2/2025.
14/2/2025. As a consequence, we dismiss the the IA number
492 of 2020.
492 of 2023, filed in SAND, sorry, in what is that? No, it was filed in
The surface applicant, the essay diary number 25919 of 2009.
NDN number 2519 of 2019. Semicolon. As a consequence, the said essay is also dismissed. And as a consequence, the order of the DRT dated 29/2/2024 is restored, revived and restored. Number 2, the OP numbers 2 and 3 are directed. Who is in the possession of the property?
The borrower himself.
A writ of number 2. A writ of mandamus issues to OP number 1 to deliver peaceable possession of the security property. What is the description?
Secured property.
Description you have to give now.
Secured property.
Secured property.
Secured mortgage.
That is mortgaged to OP number 2. OP number 2. First off, a direction issues to OP numbers 2 and 3 to take all steps to put the petitioner in peaceable possession
by taking assistance of the local police,
by taking police assistance if need be. Next 3. A writ of a direction issues which jurisdictional police? Which police? Ask and tell them. It should be a complete order.
Mangalabag police station.
Mangalabag.
Issues to so and so police to implement this order by using reasonable force against the concerned if need be, and report compliance within 30 days, and report compliance within 1 week next following, to the Registrar General of this court.
Well, the property detail I am just
that you will give in
you have to give the property detail.
it is there in
para 3 of your
it is there.
Number 2, direction. One sentence you have to write. We have not much considered which of the 2 decisions of the coordinate benches are correct, in as much as this judgment has been rendered in the fact matrix emerging from the record. That's summary of it. And show it to me. Yes, start.
Total list item 1.
I mean,
yes, sir.
I'm jumping in this very appeal matter, order annexure 1 matter, the judgment of the Honorable Single Bench matter.
He does not appear before the court. Next one.
I'm kind of placing the rule, my lord. ORS recruitment of 2011, page 79. My lord.
You have suffered order at the hands of the learned single judge.
Single judge, my lord.
What was your grievance before the
My grievance is that, my lord. Initially, I have filed the case before the Honorable Single Bench, my lord, for promotion to the post of ORS Group B, my lord. Because I was eligible so far as my earmark quota, so far as the revenue field staff is concerned, my lord. I belong to revenue field staff, my lord. Revenue field staff.
Slowly, one sentence, then pausing, seeing the judges, how we are reacting with your submission, then making the next statement.
No, I'm not reacting, my lord. And
No. How we are reacting to your submission?
My lord.
You need not have to react.
We are very sorry to say this.
My lord.
You are arguing before us. What? You want to convince us, you want to please us, and you want to snatch some fruits at the hands of that person.
But
I think it's true that the PS is cantonment police station. Mangala.
PMC cantonment police station.
Cantonment.
But your property seems to be much of a.
By that is
comes within that. It comes within that.
My lord, that judgment has been passed by the Honorable Single Bench, my lord, without going through the particular rule of ORS Group B rule 2022 by misinterpretation of that rule, my lord.
Criteria for promotion rules.
My lord.
1992.
No, criteria promotion 1992 as well as ORS recruitment rule 2011, my lord.
ORS recruitment.
There is one more set of rules.
Yes, my lord. ORS recruitment, any recruitment rules, my lord, there are 4 rules are involved so far as consideration of the promotions, my lord. Criteria promotion rule 2003, Reservation Vacancy Act 76, criteria promotion rule 1992, and zone of consideration rule, my lord. So far as criteria promotion rule is concerned, my lord, that criteria promotion rule 1992, it speaks that, my lord.
No, what are your facts? We'll go to the law thereafter.
My lord.
Tell us the fact now.
My lord, I belong to revenue field staff, my lord.
You belong to?
Revenue field staff category, my lord.
Revenue
field staff.
Revenue field staff.
Field staff, my lord.
Field staff.
Field staff.
Okay.
My post is revenue inspector, my lord.
RI.
RI, my lord.
You are RI.
My lord.
RI comes in the
revenue field staff. Field staff, my lord. According to amendment rule 2020 and 2017, my lord, 2017 and 2020, kindly peruse rule 2020 and 2000.
No, that will go to rule. You are a revenue inspector.
Revenue inspector.
What was your complaint before the single judge?
What was your complaint before the single judge?
My complaint was that, my lord. My complaint was that before the single bench, that, my lord. Though I have eligibility criteria, so far relates to promotion to the ORS Group B promotion, my lord.
ORS Group B?
Yes, my lord.
What is that post?
ORS Group B officer.
So that is Orissa
Revenue Service Group B.
Group B.
My lord.
You had...
What is he called? Assistant Inspector, Assistant Commissioner, what is that?
I am a revenue inspector.
About next
promotional post is sub-register, assistant collector.
For the cadre.
Yes, my lord.
Group B cadre.
Group B cadre, my lord.
Which has several posts.
Yes, my lord.
You are within the zone of consideration for promotion.
Yes, ma'am.
You are eligible and qualified.
Yes, ma'am.
Even then, promotion is not granted.
Granted. My name was
Though your name was recommended by
recommending authority.
DPC.
No, recommending authority.
There is a recommending authority.
So far as CCR is concerned, my lord. CCR and PAR, my lord. So far as prior to under Rule 4B, that promotion is going on according to Rule 4B of the ORS Rule 2011, my lord. That 4B is with respect to promotion.
So the authority under whom you were engaged is to recommend.
Yes. Yes, my lord.
On the basis of your CCR.
Yes, my lord.
That is ACR, whatever.
ACR. They are called CCR.
Confidential correction.
My name was recommended and so far as 5 years of preceding of CCS, my lord.
Who recommended your name?
Collector is recommended, my lord.
Collector.
What is the order recommendation letter?
My recommendation letter under my lord, through RTA I have taken it, my lord.
Whatever the date. Which character? What is the date? What is the
My lord, Annexure 11 series, my lord. Annexure 11 series plus 116, my lord. To the writ petition, my lord. Annexure page 116. Through RTI, I have collected that documents, my lord.
Which one is that particular letter by which the collector recommended your name?
Collector is recommended.
First letter, last letter. Which are they?
My lord. My lord, Annexure 6 series, my lord. Plus 96.
Yes. Which is the date?
Date, my lord, 27/11/2020.
That is the first recommendation letter.
My lord.
Read.
My lord.
27.
27/11.
27/11/2020.
He wrote that letter to whom?
Tahsildar letter, deputy collector. I am working under Tahsildar, my lord. I was working under Tahsildar.
But you said collector.
Wrongly, my lord. Tahsildar Keonjhar, my lord.
Tahsildar recommended
to deputy collector establishment, my lord. He is the recommending authority and collector is the reviewing authority.
But he recommended it to deputy collector.
Yes, ma'am. Deputy collector under the jurisdiction of collector, that is the collector of deputy collector.
How?
Well,
What is it?
Deputy collector in the establishment of a collector, my lord. Say set of deputy collector diya jaye.
So, according to you,
My lord.
it is to be addressed to the deputy collector
My lord.
under the collectorate of the particular district.
District, my lord.
Rules are like that.
My lord.
Rules are like that.
Delegation of power is there basing on which you are doing it, or you choose to send it to the deputy collector, because there are several deputy collectors.
I am not saying that the jurisdiction under the collected Keonjhar, my lord, that too, that deputy collector, that individual has been implemented by the recommending authority, Tahsildar, my lord.
So Tahsildar sent it to a deputy collector.
Yes, my lord.
But you say
Yes.
he has to send it to the collector.
Yes, my lord.
Which rule?
CCR would have put us, my lord.
Mr. G.
My lord.
Feeder category for B. Good feeder.
Yes.
Is RI.
RI.
We agree with that.
Yes.
What is the mode of promotion?
Mode of promotion is as per to 2011 notification, my lord. Rule, Lordship may kindly come to
Rule 4.
Rule 4. But to Rule 4 at page 81 and
Of WPC.
Yes, ma'am.
yes,
Go to 80.
the subject to the provisions of these rules, recruitment to the post shall be made by the following methods, namely, not more than 50% of the posts shall be filled up by way of direct recruitment through combined competitive
That's not
examination.
applicable to him.
No. B. Not more than 30% of the posts shall be filled up by way of promotion of officers outstanding merit from amongst the officers of the department as envisaged under Rule 6.
Rule 6 envisages which officers?
My lord, Rule 6 comes, my lord, eligibility criteria for promotion of that rule. No person shall be considered for appointment by promotion under Clause B of Rule 4 to the service unless he or she is a graduate, he worked for at least 10 years in any one or more than one post taken together as consolidator, grade 1, Kanungo, revenue supervisor,
There are posts, my lord.
Revenue inspector.
Revenue inspector post.
Revenue inspector, minister or ministerial officer under Board of Revenue, RDC, collectors, and other revenue offices on the first day of January of the year in which the committee meets. And
there is a DPC also.
Yes, my lord, he or she passed the departmental examination, if any. He or she is not more than 53 years of age as on first day of January in which the committee meets. Thereafter, the criteria of eligibility, promotion, selection is there.
This is a 30% quota.
30% quota.
And it is on merit cum seniority.
Yes.
Selection process.
Selection process.
So DPC selects.
Yes, ma'am.
Yes.
When the DPC met?
DPC met, my lord.
My lord, Rule 11, your lordship may kindly. The committee, yes, 84 page. The committee shall meet at least once in a year, preferably in the month of January, to prepare two separate lists of officers as are held by them, suitable for promotion and selection to the service, taking into account the existing vacancies and the anticipated vacancies of the year. The committee, while considering the cases of suitable officers and preparation of the list, shall follow the provisions of the ORB
Act.
Yes, ORB Act as is
the zone of consideration rules.
Yes,
criteria for promotion rules. Criteria for selection for appointment, including promotion rules, 2003.
2003, my lord.
What kindly tell us what is the gist of so many rules, so many acts?
My lord, one is A is, my lord.
That reservation to be followed, 57.5%.
Yes, sir.
That one, my lord.
That one. The second one is since a zone of consideration.
The zone of consideration for promotion rules 88. There is Orissa Civil Service zone of consideration. There is a set of rules, my lord. Probably he has given that.
What it says? What is the parameter?
Parameter is in the zone of consideration, my lord. The persons, suppose 20 persons to be appointed. There are 3 times of persons to be zone of consideration.
1 is to 3.
You fit it. How many vacancies?
188 vacancies, my lord.
188 vacancies.
My lord. Kindly peruse my legs, Annexure 5, my lord. Your lordship will be clear, my lord. Annexure 5. Annexure 5, page 92, my lord. To the read petition. 18/11/2020, my lord. Board of Revenue Odisha sent a letter to all the revisional divisional commissioners, inspector generals, resolution Odisha Calcutta, director land record.
IG registration, sir.
My lord.
IG
registration.
Way of promotion it is.
I am
recommended.
My lord, I am directed to say that government in the revenue and disaster management department have decided to recruit 188 officers on UR 129, SC 21, ST 38 to the cadre of Orissa Revenue Service Works Group B by way of promotion under the Rule 4B of the Orissa Revenue Service Recruitment Rule 2011, ORS Recruitment Amendment Rule 2017, and ORS Recruitment Amendment Rules 2020 from amongst the officers of outstanding merit of the department having following eligibility criteria, my lord. Following eligibility criteria.
All right, ABC.
Yeah, my lord.
Next.
Kindly peruse page 93, my lord. Page 93, para 5, my lord. The recommending authorities are requested to furnish immediate 5 years available CCRs, PARs to the preceding years to the recruitment year of the eligible officers as on first day of January of the recruitment year 2020, that is from 2014-15 to 2018-19. That is 5 years preceding CCRs, my lord. The employees having minimum 3 years of CCRs among preceding years from 2014 to 15 to 2018-19 may be recommended, and in case of non-availability of CCRs parts of any of the said period, back CCRs parts corresponding numbers of years may be
Mr. G. Appears he satisfies those requirements.
My lord.
Why learned single judge has denied relief to him?
Lordship may kindly have a look to the judgment passed by paragraph 10. Page
paragraph 10 of the impugned order.
181, page 181. This court finds that as against the total 88 posts meant to be filled up by way of promotion.
May not be. You are right. This court also finds.
Yes.
Read.
My lord, promotion indicated in Annexure 3. 129 posts were meant for UR, 21 posts for scheduled caste, 38 posts for scheduled tribe. As per Rule 4B of the Orissa Revenue Service Recruitment Rules 2011, the amended Rules 2020, out of total 188 posts meant for such promotion, 40% posts are to be reserved for revenue field staff. Taking into account the said provision, out of 888 posts
were meant to be
filled up by eligible revenue field staff, and out of 75 posts meant for revenue field staff, 52 posts were meant for UR, 8 for SC, 15 for ST category. This court finds from the proceedings of the selection committee meeting annexed by Annexure B to the counter that not a single candidate belonging to SC/ST have been recommended as against the available vacancies meant for SC/ST amongst the revenue field staff. Since the petitioners in the present case belongs to SC/ST category.
Your client is SC/ST.
No, my lord.
No.
I belong to unreserved category, my lord. That judgment is another judgment, my lord.
Let me place the entire.
Where is the principle has been decided by the single bench, my lord?
Let me
taken into consideration.
Let me place the entire.
No. This is the judgment by the honorable single bench.
This is not the impugned order.
This is impugned order is Annexure 1, my lord.
Not the impugned order. You are reading something else.
Same matter, same recruitment year, my lord. Already decided by the coordinator bench, my lord. There is because of non-preceding 5 years of outstanding CCRs of 5 years, my lord, the SC/ST candidate have not been considered, my lord. In that case, my lord, in that judgment, yes, ma'am. In that judgment, that is decided 3 years preceding CCR to be taken into consideration so far as promotion is concerned, and accordingly, the honorable court learned a single bench in that case directed to convey reputation and to give the promotion from that day.
Where is the impugned order?
Impugned order, Annexure 1, my lord.
That single judge just denied relief to you.
Annexure 1.
To show that ground is unsustainable.
Yes, well. My humble submission is that
you take us to the order first.
My lord,
material to decide the matter.
Para 10, my lord, 46. Para 9 starting operative portion, my lord. Yes.
As seen from above.
As seen from above, what is a civil service criteria promotion rules 1992?
All right, 9 you skip off. It only says a set of 4 rules have to be complied with.
Yes.
Go to 10 now.
My lord. The OCS criteria promotion rules 1992 speaks of the merit and suitability in all respect to the due regard to seniority. Rule 3C authorizes the departmental promotion committee or the selection committee, as the case may be, to scrutinize preceding 5 available annual confidential character roles.
All right, we have understood. It says rules require 5 successive years of clean service record.
Yes.
Whereas you have only 3.
Yes, ma'am.
That's what the learned judge says.
Yes, ma'am.
No, convince us.
Yes.
Rules require only 3 years, not 5 years.
My lord.
Sure.
My lord, I belong to revenue field staff category, my lord.
Correct.
Those persons, serial number 16 to 70 to 37 in the select list have been recommended. They have belonged to ministerial category, my lord. Ministerial staff, my lord. In my year mark quota, my lord, 40% quota.
No, we are not on that.
My lord.
Learned judge gives only one single reason.
Yes, my lord.
He says he needs, the DPC needs.
Yes, my lord.
5 year, what you call it as service? CCRs.
5 years.
5 years.
Yes.
Whereas you have 3.
My lord, according to criteria promotion 1992 provides stated that minimum 3 years of preceding CCR is to be required, my lord.
Where is that?
Criteria promotion 1992, my lord.
You will turn the pages of.
Yes.
Okay.
You
can turn, but don't turn.
My lord. Provided the available confidential character roles, performance appraisal reports, PARS, CCR, PARS taken into consideration.
Their lordship have written after a careful reading from page 46, 5 lines below, my lord. A careful reading of the provisions contained in Rule 3 of the OCS criteria for promotion rules 1992 and Rule 4B of the ORS rules 2011 doesn't make a decision of the selection committee requiring 5 outstanding grades of CCR as illegal, violative of the prescribed rules. When it is
Minimum
admitted
is
that
3 years.
yes,
That does not mean the DPC cannot expect more than 3. Otherwise, the word minimum will lose meaning.
My lord,
then
so far as the
it
promotion
is admitted
concerned,
that the petitioner
criteria promotion rule
has
is overridden
3 outstanding CCRs
so
only.
far as promotion is concerned, my lord.
By the time,
For 3 years, he has outstanding.
yes, he is outstanding.
To other 2 years,
At the time of promotion, recruitment promotion, my lord, he was rightly rejected by the selection committee for not having the required number of outstanding CCRs.
for
As
5
per-
years.
Yes,
Committee said 5 years.
5 years.
Where the committee has said 5 years?
It is there in the counter. It may be. It is there.
Show that.
Counter records have not come. It's only writ appeal have filed.
My lord, in the counter they have stated overriding the statutory rule as well as the letter of the Board of Revenue on the which basis that recruitment has been done so far as the promotion is concerned, my lord.
1 second. Go to that Board of Revenue
Yes, my
recommendation, which says it should have only 3 years.
No, 5 years, my lord. Preceding 5 years. Preceding 5 years, not outstanding 5 years, my lord.
Minimum 3 years.
Minimum 3 years, not outstanding CCRs of 5 years, my lord. My submission is
After making one sentence, there is full stop.
my lord.
Wait. Repeat the sentence.
My lord.
Repeat the sentence.
My lord. Board of Revenue letter speaks that the preceding CCRs of 5 years to be recommended, my lord. That to be scrutinized. Criteria promotion rule speaks that that is the overriding effect rules with respect to promotion is concerned. That is minimum 3 years preceding CCR is must, my lord. Mandatory, my lord. So far as my quota is concerned, so far as the revenue free staff quota is concerned, I am eligible. So far as the ministerial quota is concerned, they may have 5 years outstanding CCRs, my lord. So far as my quota is revenue, that is a separate list, my lord, selection list, separate list, my lord. In a separate list, so far as I having, my lord, higher scale of pay than the lower scale of pay of the ministerial category employee, my lord. Rule 8 says that the employees having higher scale of pay, they may be placed over the lower scale of pay, my lord. Having such, my lord, I have been discriminated. They stated that I having no 5 years of outstanding CCR. But Rule 92 clearly states that so far as promotion is concerned, minimum 3 years of preceding CCR to be considered. Accordingly, minimum. Accordingly, taking into consider such aspect, my lord, the coordinate bench decide the judgment which has been annexed in my rejoinder. My senior brother has stated, my lord. Taking into consideration that aspect, they have stated, my lord. I am reading. Since the petition in the respect, page 181, my lord, judgment of this single page. Since the petition in the present case belong to SC and ST category and they possess admitted by the OP, but is having 3 outstanding CCRs during the preceding 5 years, the petitioner were eligible for their consideration and against the post meant to be filled up from among the revenue free staff in SC/ST category, my lord. Because of non-preceding 5 years of outstanding CCRs, my lord, 5 years, they have not considered and they have not recommended. After filing the case by them before the Honorable Single Bench, my lord, Single Bench decided the same that has been annexed in the rejoinder before the Single Bench, my lord. That has not been taken into consideration at the time of passing to such order, my lord.
Counter is annexed to the writ appeal, my lord.
No. The proviso says minimum 3 years is CCR. CCR. Does it say minimum 3 years CCR having outstanding?
Outstanding.
Does it say that?
Yes.
Yes, that's they have admitted in the counter, my lord.
That may be not what the rule says. They may admit under
3 years preceding CCR, my lord.
No, 3 years preceding CCR having outstanding grade.
Or only it does not say outstanding, this, that, etc.
No.
It only says 3 years preceding CCR.
Provided the available considered character was proper.
My lord, Lordship may kindly have a look to the 171 page.
Covering at least a period of 3 years.
171
It does not say grading at all.
Yes.
Grading it does not say. It says 3 years. If you have 3 years, you will be eligible to enter the playground.
Yes, madam.
That does not mean you should be awarded Nobel Prize. Your eligibility is to get entry to the playground.
Yes, madam.
That's all. Once you enter into that playground, you have to play where different factors will play. 3 years is minimum to get entry, to enter the gate pass.
My lord, so far as the gate pass is concerned, I am okay, my lord. So far as the revenue field staff is concerned, there are separate gradation, separate lists are concerned, my lord. So far the revenue field staffs are one list and the minister staff is one list, my lord. I belong to revenue field staff category. I am eligible so far as my earmark quota is concerned, 40% quota is concerned. If I am available in that quota, in my quota they have been entered against my quota, my lord.
No, that's wrong. What rule which he read? It says as between them, his client should be placed above. That's all. It doesn't prescribe any quota within different officials for the in the zone of consideration. If preference should be given to you, you should be placed above the other candidate, provided your merit is because it's a selection post. Not seniority come merit, it is merit. It's a selection post.
So far as my lord, according to age is concerned also, having higher scale of pay, I have. My lord.
That is already told. That he has told.
That's only why we.
Even I have placed over the gradation list, my lord, in the common gradation list, my lord. In rule 11 is saying so, that will be
Mr.
separate
G.
list, my lord.
Mr. G, you wanted to read on particular page number. Which page number?
There is a rule annexed to the 171/92 rule.
What is meant by minimum 3 years?
Yes.
What is meant by that?
Minimum 3 years CCR.
This year.
CCR.
Suppose if he has got minimum 3 years.
Yes. He will enter. Then he will come. He will
enter
come.
zone of consideration.
Zone of consideration. He will come.
After he gains entry, what will happen there?
Thereafter, my lord, it is there in the page 51 counter. In the counter, it is written. The petitioner has the following CCRs from the preceding 5 years of 2020 as received from RDC, North Division, Sambalpur. Thereafter, they have given, as per modality fixed by the committee, the petitioner.
What is that model?
My lord.
Page number?
151.
Of the writ appeal?
Yes.
Writ appeal or
writ appeal?
PC?
Appeal.
151. Petitioner has the following CCRs.
Yes.
That paragraph you are reading?
Yes, my lord. Last paragraph. As per modalities fixed by the committee, the petitioner possesses 3 years of outstanding CCRs, 1 year of very good CCR, and 1 year of good CCR at his credit. As per decision of the committee, the candidate having 5 years of outstanding CCR have been selected for promotion to ORS cadre for the year 2020. Since the petitioner didn't have 5 years outstanding CCR as per modality fixed by the committee, he was not found suitable for promotion to ORS cadre in the vacant post meant for UR category under revenue field staff. Thus, the selection procedure adopted by the selection committee held on 5/11/2021 is as per rule as well as just and proper. As regards claim of the petitioner on outstanding merit, it is stated that the government in GA department so-and-so dated 23/11/87 has specified that the authority, while recording remarks in the CCR of the employee, should grade one among the following looking to his or her quality and performance in duty. 5 categories they have given. It indicates the highest grade of outstanding awarded to the employee having outstanding performance, and the committee has assessed the outstanding merit of the employees for promotion to the ORS cadre basing on outstanding grading award in this CCR.
No. Rule itself says minimum 3 years CCR. In all the 3 years, he has got outstanding.
3 years outstanding, my lord. It is
On what basis you went for 5 years? Why not 10 years?
5 years the committee have decided.
On what basis? Committee is not Mughal. It has to be on normative basis.
Committee, my lord, 2011 rule, it empowers.
Discretion it gives to the committee.
My lord, I'm coming to.
When rule says 3, if committee says 10, on what basis? What is the norm? Why not 10 years? So that those who do not have 10,
my lord,
we can reject their candidature and we can have the deal with the others. These things cannot happen without dash, dash, dash.
My lord.
He is having 3 outstanding credits. And committee wants to reject him because I will not fill the blank. And it will say 5. So that I will not fill the blank again. Rule itself says 3. And the first one. Second one, he belongs to the higher rank because his pay scale is higher than rest of the people.
Yes.
We're in the zone of consideration. Then what is meant by higher pay scale? Preference to be given to the higher. That such a rule he read it now.
My lord. Can I pray, my lord? Let's me call this matter. Let me get more instruction in the matter. So that
We have spent a lot of time we have spent. On what basis?
Yes, that is
5-year CCR.
that I will get that instruction.
Otherwise, the committee will run
Contrary to
amok,
yes,
like a drunken horse.
Well,
Whomsoever want it will choose, whomsoever it does not want, it will deny.
exactly. Let me get the instruction. Ask them, the Board of Revenue, how they are deciding. 5
Only
years.
that much you should say.
Yes.
Only on that case will be decided.
Yes, yes.
Rest of the things
Only
he will
5
not
years.
argue unless he wants to spoil his case. And you also cannot argue.
No, no, I will not.
Yes. Matter was heard at length. First up, on being asked, comma, learned AGA submits, seeks time to confer the official clients and to come back with an answer as to why more than 3 CCRs of the immediately preceding years was not considered, but the DPC went for 5 CCRs instead of 3. Yes, this you have to answer. You just print it. Don't make it in order. Keep it in our make it in order. When Mr. G, when will you be able to come back? Before our memory fades.
No. Sometimes a week after.
For this,
Any day. Yes. I have to call them, my lord.
on 16 we'll have.
16.
No, yeah, 16. They duplicate the same. February, March, and
20th, my lord. 20th, your lordship.
activity in the barring one column. Actually, they duplicate dates. Which date?
20th.
Sir, on 26 single months.
20th.
13 and 20.
13 and 20. 13 and 20, I am sitting single because I have to take contempt matters.
My lord.
Yes.
24th?
24th.
24th.
24th. All right. Bring a small note of what all you have submitted.
Yes,
You bring that. Yes, that helps us.